Good morning.
Good morning.
We are on the record. Today is Monday, February the 8th, and we're starting about 8:02. This is the Cosmetology and Barber Examiners Board, and the Complaint Committee will get started. I'm going to turn it over to Laura Martin, our legal counsel.
Good morning.
Morning.
I have just 3 cases that I wanted to specifically draw your attention to. And then after that, if you guys had any cases that you wanted to discuss, we could move on to that. First case I wanted to talk about was case number 6.
Page 3.
Yeah, page 3. So the reason I wanted to talk about this one specifically is because we get a lot of consumer complaints, specifically from the nail salons, where complainants allege that they have received some sort of fungus, or they were cut, or they were hurt by the pedicure tools. And usually it's so hard to prove from a legal standpoint, sort of, that the shop, in fact, would have directly caused the fungus. But sometimes it does feel pretty obvious. And in this one, the woman was able to send me bank statements showing how often she had been going to the salon, showing that she had in fact been at the salon the day that she alleges that she received the fungus. And then she was also able to show me medical records along with prescriptions from a doctor that she visited almost a week or 2 afterwards, prescribing her with fungus and the treatment. Because I'm not the expert on the sanitation within those types of salons, I wanted to give you guys a chance to discuss it. And if you think that this is the kind of cases you want to go forward on, here I have a recommendation of $500, but I wanted to give you guys a chance to discuss that and decide what you think about it.
Where is the transition from what our board is challenged to regulate the laws and the rules that they should be following, and our inspectors are doing that. Where is that line between what we are responsible for in terms of salons following the rules and when a consumer would take, in this case, legal action against?
So,
in terms of, what I mean by is suing them or asking them for punitive damages with legal involved, outside of what we do.
Anytime somebody is harmed by a business, they have a legal cause of action in a civil court. And that really doesn't have anything to do with us. A lot of times they will file complaints with our board at the advice of whatever counsel they're talking with. I'm not entirely sure that this woman is specifically pursuing her own legal cause of action. It really doesn't have anything to do with us if they're going to sue them outside of our regulation. That being said, if they're suing them for something that we regulate, it does feel, if we can prove it, that we do have the authority, or the board has the authority to regulate it. Here, obviously this came from a complaint that was filed and not an inspection, so I couldn't tell you specifically what the sanitation violation was. If somebody receives a fungus on their foot after getting a pedicure, I think it's one of those, it's an obvious violation, because all of the rules are intended to keep that from happening. So if that's happening, surely one of the rules must be violated. This does go a little bit further, though, than what we've been doing before. But because she was able to send in a good amount of her medical records, I felt this was a good case to sort of maybe try to go forward on and present to the board and see how you guys felt about going forward.
And just to add, we sent an inspector immediately. They were cited for sanitation violations. So that'll be a complaint all in of itself.
That was my next.
because this is rare, like Laura says, that we can actually get a lot of pictures and a lot of stuff, and we don't, most of the times we've had to close these because even before Laura, legal counsel's advice was, this isn't our avenue, this is, not where they would sue the business for doing this. But we went right back and did find some sanitation things that needed fixing, and that agreed citation will follow its course, and if they don't pay it, then come to legal and so forth.
I guess, one, I'd really like to look at the sanitation rules around nail salons. All I can speak to is in my experience, we used to offer nail services. On our very first inspection 7 years ago, a woman, I believe her name was Judy, but I don't think she was a former inspector and had been with the state board for a very long time. She literally made me unscrew and take apart our pedicure station so I could see how dirty it was. And that how difficult they truly are to clean. It was eye-opening for someone who had bought a very expensive pedicure unit and was following all the sanitation, but truly showed me that most of the nail pedicure units cannot thoroughly be cleaned, and they are not being thoroughly cleaned. So I think that there probably, my opinion, would be a very thorough going through what are the inspectors looking for. I also think in my experience, there are nail salons who it looks like they're autoclaving instruments. They're putting them in packages. I think people would clearly tell you they are not. And I don't know exactly what inspectors are looking for. I just want to make sure that this doesn't open the floodgates for, I didn't like my hair when it was done. I didn't like the color that was applied. I got some sort of scalp burn. Because I don't know that that's within our jurisdiction.
Well, I will tell you, the floodgates are open. We do get complaints all the time that are similar to that, and our complaint coordinator usually after conferring with me will send them a letter back saying this isn't within our jurisdiction. But anytime something would have been, anytime the harm that the person received would have necessarily come through a lack of adherence to sanitation rules, I think legally we should open the complaint and at least investigate it. Since what we can do, if you're not comfortable going forward with consent orders, is I can change this and we can close these complaints with letters of warning and then just always send an inspector to follow up, which is kind of what we did here just on our own volition, but that can be more of a policy if you're more comfortable than what I have here. That's an option.
I'm not uncomfortable with the fine.
Mm-hmm.
I'm just putting it out there that I think it's very interesting when restaurants get their grade from the health inspector. It's on the nightly news. And it can make and break their business, right? You and I would not choose to go to a restaurant that we saw on the nightly news that had failed their health inspection. We have salons in town who fail every day. And other than that piece of paper that's behind a desk that no one pays attention to from the consumer, there's very little information, for my opinion, from the consumer to what's really going on. And you're right, I can't imagine how many complaints you get specifically around nails, let alone everything else. So my question would be, is there a way to better notify the consumer as well?
You mean when there's a sanitation violation?
We are, the current disciplinary action report is on the website for all of Commerce and Insurance. It's by month, and you'd have to be looking really close. So it is going to be improved. It's on the works to where if you wanted to look for the nail shop in your corner, that you go to, you could search it and see any history. That's our goal. So we'll get there. We're not there yet. We often get those calls with those type of questions and complaints, and I guide them to the best that I can, because I don't want to say don't go to this shop because all others have the same type of complaints. That would be wrong. So we guide them the best that we can, but I think that's really important, having the history out for the consumers. I think we've started doing videos to let the consumers know what's out there. And our goal on the website is to have these type of videos, if you will, for consumers, and to make them known through hopefully even the media that these things are out there to walk you through what you should look for, which is the inspection sheet and maybe even articles on what sanitation should look like, so that as an educated consumer, when you sit down to have a pedicure, you ask these questions and you know what to look for. So definitely education. And then the shops and the schools, I think, we're continuing to look for ways to do it, like community groups. So in one section, we can have salons come in to talk to the inspectors, to talk to us, and to look at those. So that's my goal in the next few years, that we can now, having changed systems and database and made a lot of other changes, we can focus on that big piece, the education to the shops and then the public, so they know what to look out for. I agree with you wholeheartedly.
Well, I just would not want the nightly news or the investigative reporters in this office saying, you knew this was going on and you haven't done anything about it. So I think you're right in following through, right? We can't be blind to this and just say it's not our problem. I'm just curious as to what precedent, how we want to do this going forward. And it's not that someone walked into Bobby's shop and is now approaching us because they don't like the haircut they got.
Exactly. No, and she had, what Laura says, she had really the best proof we've probably gotten.
Of all of the complaints of this nature that we get, they usually make it to the legal report, and you probably hardly notice them because I always say close with a letter of warning, or
I've noticed
Close-
because you're like, I can't tell.
yeah,
There's no.
I can't really tell. And
You don't know if they
here,
went to the
there's-
water park or they just have a dirty shower. Yeah.
And here, there's still that possibility, but the link is the smallest I've seen. It would be hard to look someone in the face with all of this medical documentation and say, but maybe also you just stubbed your toe, and yeah, it would be hard to say that. That's still there though, which is why I wanted to give everyone a chance to talk about this case, because I think there's enough evidence going forward, but there's definitely more of a link there than your standard inspection sheet type of complaint.
But you're saying here that she sent a picture and the wound was clear on the picture, so she was injured.
She clearly has an injury. You can see the wound in her picture. More than that, I have her actual medical records from her doctor and her prescriptions. So she definitely has received a fungus of her foot. It's pretty painful, according to her, and you can even see some of the cuts on her foot. And then also she sent in the records from her doctor. The problem is, again, usually when I get these, it'll be, I went to this salon one time. A lot of people pay cash, so they can't even prove it. This woman sent me her bank statements from the last 5 months showing me how often she goes to the salon. She says she has never gone to any other salon. Granted, she could go to another salon and pay for cash, but it just started to build up. This is the only salon she went to. This is the injury she has. Here is the day that she says she was there. Here is the credit card statement showing she was there. Here's a week later, a doctor saying she has foot fungus and
And
prescribing
it's coupled
her
with the fact the
medication.
inspector went back out and I mean, and that's I hate to say that's proof, but you sent an inspector right out and he verified that yes, this is not.
Well, as an instructor, when I'm teaching my students and I'm going over the sanitation and stuff, teenage girls nowadays, they go get their hair and their nails and everything done all the time, and they say to me, Miss T, they don't do this in the salon. I said, then you don't need to be going to that salon. That's just the way it is, but there's so many that get busy out there and they don't follow the sanitation. And we definitely don't want what happened in California in 2000 to happen here now. So I think we ought to follow through with it.
Are you comfortable with the amount? So they do now, because now they've been inspected specifically to look for sanitation. The first time somebody is cited, I do think it's better policy to go a little bit lower, but, I mean, 500, it's relative. For some shops, 500 might be nothing. It might not be a deterrent at all, and for other shops, that might be some, you know, so.
You would advise her that if she wanted some sort of repayment for her doctor's bills, that she would need to pursue that on her own with the salon.
Okay, if you'll turn to case 37, it starts on page 13 of the report and ends, oh wait, no, it's on page 14 of the report, sorry. So, the last meeting that we had, and, you know, Mr. Gambus isn't here, but this seemed to really be his leading charge, was that we were gonna start going for revocation the second time a shop got caught with employees trying to leave or hide. And yeah, you can read what happened here. It's pretty bad. It is only the second time that they were cited for this, but the first time with a $3,000 civil penalty, you can imagine they had 3 unlicensed workers. I've assessed revocation, which I think is what the complaint committee wanted, but since this is sort of new, I wanted to give you guys a chance to read it and be sure that this is what you wanted.
Give the date of the previous citation. I'm just sheerly curious, was it 6 months ago or?
Well, with a case number 2015, it would have happened within the last year.
Not that long ago.
Not that long ago.
Yeah, I'm good with that.
We were previously going for that third case, you know, the third time that we have this, and I think we revoked maybe a couple like that fell into the third time, and that's when I think Mr. Gambusa at the last meeting said, you know, this is enough. There's a difference when you're hiding in the cabinet under the table and running out the back,
Under a
and that's
blanket,
not
I
okay.
mean, really?
Bobby, you got people running out of the back of your shop? Or you hide them in the cabinets?
In the cabinet.
In the cabinet. I wonder if 1,000 is enough.
Here I don't have any penalty.
Right.
I just have revocation.
Done.
Yeah, that's true.
I mean, I think this directly leads to what we discussed previously with sanitation issues.
I was looking at the wrong one. Okay, yeah.
I thought I had 3 cases, but I actually misspoke. I only had 2 specifically that I wanted to talk about. Did you guys have any cases you wanted to?
There's a total of 96, so we'll give you all plenty of time to review, look at your notes, or just go through them all.
Thank you for your thoroughness in all of this.
Cool.
It's never dull.
It really is not. No.
I'd ask a question. When we first started last year, and it was brought up at some point about license, pictures being on the license, what did we ever do with that?
That's gonna be a ways away.
That's still
It's
away.
definitely what I've wanted forever, I think what everybody's wanted.
Right.
So we're looking at different options. Among them is the option that licensees are gonna be able to print their own licenses as well, as opposed to just waiting. So once it's updated electronically as your receipt you'll get a link to get your own license, which is fantastic. And then through the computerized aspects, verifying a license is more and more really the way to go for the shop, for the managers, the owners. You can just verify even if it hasn't gotten to the person. But yeah, so they're still looking at a way to have the picture printed. But if we go the route of everybody printing their own, then that may actually change it. We'll see. The other option that we have is for those that test in Tennessee. We've got the pictures through PSI. Is maybe having even the link to that photo. So all that is still in the works. Yeah.
I didn't know. I thought we.
That would be great.
All right. This is not anything to do with the topic that we're on, but I would like to commend our inspectors for being professional out in the fields. They're doing a good job.
Thank you.
Great job.
Mr. Fingers. I will definitely let their direct supervisor, the director, James Olgan, know, and the next time we have training, because it's not an easy feat. They're
Right,
constantly training and trying to improve.
I'm
So thank you.
in the shops every now and then, and people are by my place, and they talk. They're really impressed at some point. And so, of
Good.
course, not sometimes we get something else, but 90% of the time they're favorable.
Wonderful. Thank you.
Does this make them feel better too, the revoking of the
Yeah, I see for them how it's hard not to take it personally, but sometimes it does seem as if though they've done all the work and then it just keeps happening. So since I came on board, I guess a year ago now, there's been a lot of changes. I don't know, changes. I have tried to communicate with the inspectors a lot about what exactly it is that I need for cases to be strong enough to go forward. And once they realized that I was not their enemy, they have all really tried to live up to that and get us exactly what we need. Because I'm sure it is very frustrating for them when they've gone to the shop, they see how bad it is, and then I have to recommend that we close it. So
documentation is important and the pictures.
documentation
and
is important, the pictures. A lot of these cases, especially the unlicensed ones, are coming with pictures now. So that makes the case stronger. So it's pretty good. There was a case in here. I should have written it down. What was the one with Hudson? I know I had told you guys that there had been issues with inspectors, and it just reminded me that there was a case where an inspector was in a shop doing an inspection for, I believe, a license change of ownership. And I don't even think our inspector was intending to write them a citation. She just saw small violations that she was trying to help them with. And the owner of the shop began, I believe, to try and intimidate her by talking about how he owned a gun and that he knew how to use it, and just really giving her a hard time. She was very upset. She was obviously told to leave the shop by her supervisor. She did file a police report, but it was several days later, so nothing really came of that. And I believe I recommended a $500 fine. Yeah, it's case 31. So,
That's on page 11 on your iPads. And we brought this case up the last time we had something with an inspector being disrespected. I think you all at that point, mentioned how you want to make sure that the inspectors are never treated like this.
Laura, on case 70, I think it's a typo. It's on page 24. It says the paid the renewal
yeah.
fee before the
Inspection
inspections.
date, yeah.
So let me ask you this, just for consistency. It's case 19. No, excuse me, case 20 on page 8. It's an unlicensed case. 3 unlicensed individuals. You have a settlement assessing $1,000 per individual. They have a previous 2,000. Is this a 2-strike situation?
The last time they were cited for what appears to be unlicensed activity was in 2014. And here they had I was being pretty sure about that part of it because that's what I thought you guys wanted, but this potentially could be a second strike. And I could make the decision for revocation if that's what you would like.
No, I mean, I think there's a big difference between people who hide and run out of shops versus just owning it. I don't disagree with you on that front. I think it'd just be helpful in the notes if there is previous history to list that. Just because we don't know that previous complaint, if it was for the same thing or for something different. It just, if we're getting serious about this in terms of how many chances you get and within what time period.
That's my next question. Do we have a time limit on the 3 strikes? Or is that,
It would be up to you all. So far, no.
That's-
We've obviously not set a limit, and it isn't 3 strikes. My understanding, as we talked about it last week and debated it, is that the committee in particular, and I think the board all agrees as well, is if someone is running out and they're hiding and they're putting their staff and employees through this, and they themselves think it's okay to, the minute that the state walks in, we hide and run, that's very different, or a little bit different at least, than they're here, yes, they were working, we're gonna try not to do it again ever. So we've not set a time frame. Obviously, if it's back to back and within a year, then it's served no purpose at all. And we're not in this to make money from the shops for citations. We really want them to improve what they're doing, follow the statute, and, service the public correctly. So I think that's a great idea when there's similar high unlicensed, to list some of the history for you.
Maybe something that we'd want to bring up in front of the greater board. Just say, hey, with this history and this amount of time.
And the second revocation that we're going forward with, any time that it's that bad is running out, that we are going to be revoking.
It seems like the very next one, cases 22 through 24, just when you see that history and those amounts that have been assessed. And then you're looking at another $2,000, and to your point, at some point, $10,000 is a lot of money in the last 2 years.
I can be more consistent with just if it's the second unlicensed and ask for revocation.
We just flag it for review?
I thought specifically what was said at the last meeting is when people were running out the back door, that this is a shop that has sort of perfected how to run an unlicensed.
I think they all probably need to be reviewed. Right? If
Okay.
you've got someone hiding in blankets and doors and secret cabinets, that's a whole different situation. But if you have consistent unlicensed, I think that's also something we need to be very thoughtful about.
The last at least 6 months, if not a full year, that third unlicensed, that's where we've been going with the revocation.
And I feel very fair about that.
Yeah.
Want me to change those? 20, was it 21, 20? I guess it's, 20 through 24 to revocation.
I think I'm fine with a third strike there. If you could just make a note in the notes that this was their second, because again, I'm assuming that the first complaints were unlicensed, but if you could verify that and just say this is the second in, it looks like, since 2014 for both of them. So that clearly the next time it would be boom, boom. But yeah, I agree. If someone is blatantly hiding and running out, we probably don't need to wait for them to do that a third time.
No.
And that first, not that it's great that first time that they've got the unlicensed, but the board has approved that to be part of the agreed citation. So they really could very quickly resolve it, know that they're at fault, deal with it, and not even come before you all. So you're only getting those from the second time. And, our hope is not to make money from this. It's that there isn't a second time, so.
Right.
Yeah. Are there any other questions? It's about 8:35. We'll wrap up in about 5 minutes. Give- Yeah.
One more and let you go. What is our policy on whereas that at some situations where there's a gun, what do we have? Do we have anything on that?
We don't really have a policy on that. This is Tennessee, state law. It's a private business. They can have a gun. They cannot use their gun to intimidate our inspectors or students or anyone else. I think that's a little bit different, but we don't have a policy because I think that would I think that would go against the state.
And the reason I asked that, because I've go in a few shops where the people behind the chair are wearing their guns. And so I don't know, intimidating or what.
They're wearing, is that you said?
Yeah.
Wearing? You can see them?
Yes, do we have a policy where the gun needs to be covered, or can it be out, shown, or what? Is it legal? I don't know.
Currently, there is no policy.
Okay.
I think that it would be difficult if somebody has a license to carry. I'm not sure that we really could
Override that.
override that.
Okay.
Of course, schools that are getting funding from federal funding have different federal policies, which of course then overrides state policies. But I don't know that as a board we could come up with a policy about guns.
Well, I'm satisfied with it. I just didn't know where we
it's
stood with it.
controversial. I'm sorry, what?
I said I'm satisfied with it. I just didn't know
Okay.
where we stood.
I've seen in certain businesses where they post something outside that just says no guns in our establishment. We have guns all the time, and I don't ask. But I know that quite a few of my customers are actively carrying.
Right.
Whether or not I agree with that is a whole different situation, but it's always catches your attention when they cross their legs and there's a gun.
I understand.
He gets a really good haircut.
On 85, case 85, is that all these complaints previous is unlicensed activity?
This is a case where the person actually came in and spoke with me, and I did go and review all of her complaints because she said, I have no idea what you're talking about. This is the first time I've had an unlicensed person. So when I went and reviewed her complaints, they actually hadn't had an unlicensed person in their shop since 2012. And then as I was And then she even she kind of didn't really agree that there had been an unlicensed person in her shop in 2012. When I explained to her, well, you signed this consent order, which means you agreed to these facts. And it appeared to me, speaking with her, that she did not at all understand what signing a consent order in 2012 had meant, and that if she had known that this was going to be her history and go against her, and that signing it meant she agreed to what was in the report, she wouldn't have fought it. Told me she just signed it because she wanted to settle the case peacefully. So I personally felt a little bit uncomfortable holding that against her. Certainly anyone can lie to me and tell me they don't understand, but it appeared to me that she did not understand at all, which is why I asked if we could change from revocation to. And she does have a lot of history. Most of those are going to be different sanitation, or I think there was one even for a name tag complaint, which we don't really assess fines. But I did review all her complaints, and she had not had an unlicensed person since 2012. I did tell her personally that now that I've explained to her how the discipline process works and what signing her name to consent orders held to it going forward. So if she doesn't take this third chance seriously, that I would not be able to help her at all.
Counsel, I'm all right with it.
That was all the questions I had.
The three of you, I think so. Ms. Tansley, are you in good shape, or are you still reading through them? I don't want us to stop.
I'm fine.
Okay.
So the motion would be, you want to make a motion?
I'll make a motion to approve the legal report with the changes that we discussed.
Second?
All in favor, say aye.
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 Opposed? Motion carries.
Thank you.
Thank you.
That wraps it up. Thank you very much. Very good. You ready now? Okay, we will get started. Good morning.
Morning.
Today is Monday, February the 8th, and we are going to be starting the Reciprocity Committee meeting at 8:55. And if you would, on your iPads, turn to our first reciprocity applicant. You have before you an application for reciprocity of a natural hair styling license from New York for Ba Aminata. The certification shows the license was granted in March 2014 with experience from New Jersey and no exams. Ms. Aminata has provided attestation of 3,600 hours obtained, as well as a letter from a client and her own recap of her experience. I'll give you all a minute to review that. My recommendation is that the applicant take the Tennessee exams.
Just for the natural hairstylist.
It is, yes. And New York, of course, on the certification says no exams, licensed in 2014, and it looks like they necessarily haven't reviewed any education. They've just accepted her work experience. We have no record of the hours. However, given her letter recap and the page 7 of your iPads, the person that's had, I figured that can count as work experience, the license in New York, rather than to demand more proof of education, which she may or may not have. I think the exams would be the way to be consistent and make
Because
sure.
she's not taking exams.
No, not at all.
Second.
Motion and a second that she take both Tennessee exams. All in favor? Aye. Motion carries.
Application for reciprocity of a manicurist license from New York for Nen Mei Cheng. Certification shows initial licensure in March 2011 with 250 hours, and the written exam taken in Chinese. Given the date of the licensure, she does not have the minimum 5 years experience, but the letter from an employer states she has been working since 2008. My recommendation is that the applicant then be approved for reciprocity. And the reason for this is the language exam issue that we would have if the board is still more comfortable asking for the exams. Again, considering that she's been working since '08, and New York does apprenticeship type of thing, so that is very possible that it was legal work experience. The exam that she has is only the written. It's in Chinese. We could go with the practical here. I think we'd struggle with the language issue, so I'll leave that up to the board to.
Looks like I see where she took the practical and the written. On page 10. 10. Is that? Practical.
They're two different licenses. So if you look at page 10, we're right now addressing her request for the manicurist license, and that is on page 10, the nail specialist. There she's taken the examination. It's in Chinese, but she's taken both. The second page is the waxer, and we're going to go back through here in a minute, and she's asking for both licenses, actually. So that way we can make a decision on the waxing, because we don't have a license that compares to that. But yes, you're correct. On the manicuring, the examination is both. The written is in Chinese. She's got the practical. That's the reason for my recommendation to approve her manicuring license.
Make a motion to approve our manicuring part of the,
Second.
Motion and a second that we approve reciprocity for her manicure license. All in favor? Aye. Motion carries.
Given that, again, we're looking at a license from New York for Nen Mei Cheng, and her license from New York for waxing would be comparable to our aesthetics license, but at the same time be very require an awful lot more hours for it. She shows that since 2011, she has 75 hours in waxing with only the written exam in Chinese, and that's the one on page 11 on your iPads. Tennessee doesn't have an equivalent of this license, although her letter from the employer states that she's been doing both the nails and the waxing since 2008. She is still short 675 hours to compare to anything. So the recommendation I think, is to send her a letter stating that the 75 hours could be accepted. She'd be short 675 if she wanted to pursue the aesthetics here, and then obviously take the exams.
Essentially grant her credit for the 75 hours towards her.
Right,
Okay.
right, if the board's okay with that.
make a motion to have her take the aesthetics course in Tennessee and be credited the 75 hours.
Second.
Motion and a second that she's credited 75 hours toward the aesthetics license, and whatever. All in favor? Aye. Motion carries.
Next is an application for reciprocity of an aesthetics license from New York for Candy Fisher. The certification shows license was issued on August of 2014 with 600 hours by examination. Ms. Fisher has provided a letter regarding her experience and certification supporting 150 hours obtained on using lasers and other advanced items within the aesthetics field. I will give you a chance to kind of look at those. My recommendation is to accept her reciprocal license, even though we don't do the lasers and the advanced aesthetics. Clearly, she's continued her education and done a little bit more than the basic aesthetics. Is Ms. Fisher here?
Any approval of this on her still wouldn't authorize her to do lasers here.
Correct. She would have to still work under the medical purview and board if she decided to use that. Her question to me, and it was a good one, is and she had taken other certificates, but they weren't this close to our industry. But these two pretty much are that advanced level, if you will. So she is still short the hours. She just said, I don't know what else I would learn in those hours, because she's been practicing mostly in a spa that offers both the things and using the medical side. Her letter is on
She was
page
licensed
18.
in 14.
Yes, yes. So she couldn't have the work experience we require regardless.
What's your recommendation?
That we approve her license based on the 150 extra hours she has.
And she needs to take the written part of the state board?
We definitely could, if the
Make
board's
sure,
more
'cause it's
comfortable
from-
asking her to take them. The written, we can. PSI and I have had long conversations. The practical is very easy for us to put them through, because it's that last exam, they're given the application, they're put through. But when we have them take the theory, the automatic process is that one more is missing. So it becomes a little bit more difficult to track if they just do the theory. It's not that it can't be done, but I think if we're going to ask for one of the two, we either maybe ask for both or go with the practical. The advantage to the theory is that our rules and laws are in there. And that's huge. I'm hoping in time, maybe as we evaluate reciprocity in our numbers, if we can develop something to where maybe in time all reciprocal have to take our rules and laws. That would be lovely.
I would think that, I'd make a motion for her to take both portions of it
Take,
and to waive her 150 hours with her experience.
Second.
Motion and a second. She take both exams. All in favor? Aye. Motion carries.
application for reciprocity of a manicures license from Pennsylvania for Phuong Nguyen. Certification shows initial licensure was April 2003 with 200 hours by examination. Ms. Nguyen has provided tax records for the last 5 consecutive years. However, 2013 and 2014 show a Tennessee address and income. Conversations with her and her husband have given conflicting information, including admitting that she was working in the shop in Jackson. My recommendation is that she take at least the practical. I'll let the board review. They own a shop in Tennessee, so obviously 2013 and 2014, Pennsylvania is not one of our neighboring states. It's hard to work in both states, but we've been given various pieces of information.
It has 200 hours instead of 600.
Correct. It goes back to 2003, so it's very likely that between 2003 and 2012, bless you, she was in Pennsylvania and working. But her tax records show a Tennessee address since 2013, so in reality, those 2 years wouldn't count of the last 5.
What I'm looking at on her little, on the note here is that her job was to simply clean the salon and answer the phone. And
Yeah, once the information was not coming through the same, and there was an issue with working in Tennessee without a license, that's when the letter was written. And of course, we didn't have a January meeting. I'm for the exams, whether both or one. I think we'd absolutely have to make sure that it's all there.
huge difference in the hours, except for the work experience, and the work experience is broken at the end. That's tough.
Pennsylvania does do the examinations, but we, at least at this point, have them now in 2 languages that have been in the past a problem not having them, so.
I think she ought to take the difference in the hours, and even with the apprenticeship program, she'd really be only having to do 100 in the school and then go apprentice under him that'll work with her. Or, I mean, I don't know.
At a minimum, I'm thinking she has to take both tests at a minimum.
Right.
I'd like to see some more hours there simply because of the work history. Just from what I'm reading here, I'm getting a little bit of disingenuousness, is that the right word, in this, so trustworthiness.
She wanted to say she had the experience, but then when it became an issue that she's not licensed in Tennessee, then she wanted to say she didn't. She was
Now, from '03 to 2012 would give us the years that normally I
20
can't
years.
approve, right.
And then the issue would just be that they weren't the last consecutive years.
Right.
So,
That's the main reason that they're before you, and the conflicting information, obviously. I think the 2 exams would be wonderful, especially because they already own a shop in Tennessee. I mean, they're established. So I think that's the reason the tax returns came through, and the information that they didn't know would all be reviewed the way that we review it.
she'd be more likely to take the exams than try to get the hours, and I think she's going to work regardless.
My recommendation, I mean, I started with the practical, but I think that both exams, and given that they are offered in a language that she'd be able to, that would be a,
I'd move it to take both exams.
I'll second that.
Okay, motion and a second that she take both exams. All in favor? Aye. Motion carries.
application for reciprocity of a manicures license from California for Vu Nguyen. Certification shows license was issued in August 2001 with 400 hours by examination. He's also licensed in Wisconsin since 2003. Mr. Nguyen provided tax records for proof of experience, but does not have the records for 2013. That's the only year he is missing. My recommendation is that he be approved for reciprocal license.
His original license was where? Wisconsin? Or is that the last
2001,
one?
California.
California.
is short just the 200, but
Okay.
they do the exams. And then in 2003, he moved, and you can see that they accepted everything from California.
He took the practical and written in Iowa?
In California.
California
Yes, ma'am.
in 2009.
He received reciprocity from Wisconsin.
Yes, reciprocity accepted his information from California, and so that's how he got that license. So, and that's the current license through 2017. So he's been working in those two states.
I feel comfortable if they take our written part for our state laws. I don't know if they're different than where he's coming from or not.
The only thing he's missing is tax records for 1 year.
For 1
So
year.
we have to be careful, because in the past, now if they didn't have the 5 years, that's different. He in essence does, because he's got 2014's tax records, and he goes back to 2001. So he's been licensed and tested for a long time.
I would move that we accept his reciprocity request.
Motion and a second that we grant reciprocity. All in favor? Aye. Motion carries.
Next, we have an application for reciprocity of a cosmetology license from Pennsylvania for Priscilla Pearson. The certification shows an initial licensure in 1994 with 1,250 hours by examination, and she is also licensed in Florida since 2010. She's provided tax copies of her 2013 through 2015 tax records. She's unable to find additional records due to the move and things being in boxes. Since she's just undergone a move, she's also been offered a job. So she and I spoke Thursday, and she begged that I present her to the board. It's not that she doesn't have tax records. They're just not anywhere near her. She goes back to 1994, like I said. So we don't have proof of the last 5 years. So my recommendation is that we approve of her reciprocal reciprocity given her examination, years of experience. She's just lacking the paperwork in the middle of the move.
I would so move.
Second.
Motion and a second that we grant reciprocity. All in favor?
Aye.
Aye. Motion carries.
Application for reciprocity of a master barber license from Illinois for Zoran Stepanov. Certification shows initial licensure in August 2003 by endorsement from Yugoslavia. Documentation provided shows that he completed trade qualifications in 1992. They list also the classes that he took. He is able to provide employment records, and that's also on your iPad for review. My recommendation is that the applicant take the practical exam.
Practical?
We can do both. The issue with both is the language. And his license is in Illinois. Illinois and Michigan, Illinois in particular, is the one that allows a translator for their exams. We can start with both and see where he goes on the theory, but the language is probably the difficulty we're going to have.
In the military from
Yes. And he's got his, the socialist card for the employment that has to be tracked. So he's been working there. These are those kind of documents that normally we don't know what we get, but that's
Right.
not the case here.
I'd move that we accept with practical exam.
Practical.
Motion and a second that we require him to take the practical exam. All in favor?
Aye.
Motion carries.
Application for reciprocity of a cosmetology license from Connecticut for Lisa Vitati. Certification shows initial licensure in May 1989 with 1,500 hours, but only a theory exam. Ms. Vitati and I had spoken regarding all of the years in the industry. She says she's worked for 26 years and is requesting consideration to look at all the experience she has and please waive the practical exam. That is the only thing that she would be missing. And my recommendation is that we approve her license for reciprocity.
motion to approve her for reciprocity.
Second.
Motion and a second that we approve her for reciprocity. All in favor? Aye. Motion carries.
Next on your iPads, we have an application for reciprocity from Georgia for Mr. Tommy Vo. Certification shows an initial licensure in February 2007 with 1,500 hours by examination. This application would, under normal circumstances, be approved by the director and not have to be presented to the board. Mr. Vo, though, causes some concerns. In 2014, he applied for a manicurist license from Texas with hours from one of the schools that was being investigated. He appeared before the board on June 2nd of 2014. He explained how difficult this decision was, but the board still denied and said that the hours from those schools could not be accepted. He's also had repeated conversations with board staff regarding this. At no point during the conversations back in 2014 did he state that he had a license in any other state. And so in January, I spoke to Mr. Vo and explained my concerns and why I couldn't approve him, and asked about the hours in Georgia and the license in Georgia. He explained and has then put it in writing. So his email to me is on page 46, where he states that he didn't think that his cosmetology license would allow him to do nails, and that's what he wanted to do. But now he realizes that the chemicals are affecting him and he doesn't want to do nails. He would like to go, he would like to be able to do hair. And so, again, with that license, I vetted it the best way possible. It all looks to be in line. I would recommend that he take the practical exam. I'll leave any other questions or conversation that the board may have or concerns. You all may remember him appearing for the board. He was upset that we denied his license. And what you see on page 48 and 49 is our new core system. It kind of I love it. It recaps just about everything. It goes back to the beginning of time. I might have even deleted some at the end, but it'll show complaint history if it's there, shows our notes. So his first application goes back to November 5th of 2013.
It was June of 14. Was that the former board?
Yes, August, we had the new board sworn in.
He's asking for a reciprocity for his cosmetology license?
And he meets those requirements. Georgia is 1,500, both exams. They test in a lot of the different languages as well. Really, the only reason I could not is because I knew we had gone over the conversations about the manicuring. But his explanation in writing on the email is that he didn't think he could do both.
And you're recommending that he just take the practical?
And of course, as a cosmetologist, he can do both, so.
Right.
Got the experience there, I mean, the years.
When did he get the cosmetology license?
2007, way before.
And he didn't mention that?
No, and I personally have had conversations with him in the board office, not just on the phone.
Make a recommendation that he take the practical part.
Second.
Motion and a second that he take the practical exam. All in favor?
Aye.
Motion carries.
Application for reciprocity of a cosmetology license from Florida for Terry Wenslick. Certification shows an initial licensure in May 1998 with a theory exam only. Ms. Wenslick submitted an email requesting the board waive the practical exam requirements since she's been licensed for 17 years. My recommendation would be that we approve the reciprocal license.
1,200 in Florida, 17 years.
Is it coming before us because of the lack of hours?
Correct, correct.
Have the tax records to back up her.
She doesn't have all of her tax records, but she's got various years of experience and the letter of recommendation. What she's missing is the practical exam, so that's what she's asking to be waived. So the proof of experience is there. It's just the practical. And the last time that we spoke about that, I asked if the committee had a cutoff year for when, obviously if they've only been licensed for 5 to 10 years, the committee was pretty sure that they had to take the practical, but when we exceed that, so I don't ever present those unless it's either military or the experience is so vast in other areas that you do need to consider it. But in this case, she's been licensed since 98. But we don't have that magical cutoff. I think the committee had decided that you wanted to hear them and just on a case-by-case basis decide.
Do I hear a motion?
Okay, I think I would move that we accept
I'll second.
reciprocity. Yes.
Motion and a second that we grant reciprocity. All in favor?
Aye.
Motion carries.
Next, you have an application for reciprocity of a manicure's license from California for Bill Wilson. Certification shows an initial licensure in 2000 by examination with 400 hours, and this is the license from California. Mr. Wilson has been trying to obtain a reciprocal license since July of 2015 with the board. He's also licensed in Alaska, and several years of the tax returns he submitted had Alaska income, so the board kept asking for the Alaska license, and we just weren't connecting. Nothing was ever coming. He actually visited the board office, and we were able to help him pull the electronic license from Alaska. And then there is an email from the executive director Ms. Spencer with the licensing board in Alaska, explaining that it was probably a language issue. He had not properly asked for the certification from Alaska or paid the $20, so they were able to confirm that he has been licensed in Alaska and that the information we have is correct. He's also been able to provide some of the tax records we needed. He paid all the fees for his Alaska license, and in January, we were able to confirm everything. He has, however, been in Tennessee since 2012. So he's been able to provide his profit and loss tax returns, so he owns a business, which does prove experience in the field. He just, from everything we can tell, hasn't been doing the manicuring, which is good.
Excellent. Yes.
Yeah. So my recommendation is that we approve his reciprocity.
Approve him.
Second.
Motion and a second to approve for reciprocity. All in favor?
Aye.
Motion carries.
Application for reciprocity of an esthetician's license from Oklahoma for Roxanne Wilson. Certification shows initial licensure in September of 2001 with 600 hours by exam. Ms. Wilson is also licensed in Arkansas since 2006 and in Florida since 2013. She submitted a letter from her employer providing work experience between 2008 and 2013. Since 2013, she's gone back to school to be an RN and has included an email explaining her plans. Given the licensure in several states and her years of experience, my recommendation is that we approve her reciprocal license.
Make a motion to approve her.
I would second that.
Motion and a second that we approve for reciprocity. All in favor? Aye. Motion carries.
The last application on your iPads is a request for consideration of a master barber license from Alabama for Mr. Jax Horton. Mr. Horton was previously presented to the board at the November 2nd, 2015 board meeting and required to take the Tennessee exams. Certification is from Jefferson County and states that Mr. Horton completed 1,500 hours and passed the theory and the practical exam in order to obtain his license in September 2015. The board office spoke to the commissioners from Jefferson County's board. So one of the commissioners in particular, and I had a long conversation, he explained the process. And although all counties are probably not done the same way, because we've gotten several that give no information at all. So I think in August, October, and then November, we had several come through of the barbers, and we recommended on all of them all the exams. We're presenting this one given the letter coming from their commissioners, and that would be on page 69 and 70, and then the certification is the last page on your iPads. So in my conversation, it sounded like they really have, for all the years that Alabama didn't have the licensure for master barbers, they really held their standards high and vetted everything and did the schooling and the exams. And he told me that all the other states have been accepting those, and I explained why we weren't. It's not a state certification, but I felt that it was well worth presenting and their explanation from their commission. So
We're
that we-
fairly sure that this school then is an approved school and all that.
yes,
They've got the 1,500
yes,
hours.
correct.
They're just regulated by counties down there now.
And now they've got the state, licensing, but in this particular young man's, he finished everything right there and didn't need the state licensure in his eyes because he was moving here. So I think this letter is good for us to have from their commissioners because it does show us everything that they cover from the curriculum on, and maybe when we get those county ones, we can, at least for this county, look at it a little bit differently.
It's a little unusual that a student graduated in that state and then didn't apply for a license in his own state, but it's not unheard of.
Right, ours do that.
I've been
Yeah.
familiar with a few of them myself that have done that, so.
Yeah. So in his case, my recommendation with us reviewing it a second time would be that we approve his reciprocal license.
I'd make that motion.
Second.
Motion and a second that we approve for reciprocity. All in favor?
Aye.
Motion carries.
That is the last application we have, so unless the committee has anything else, we'll take a break until we start at 10. Thank you.
Sounds good.
Thank you.
I'm good. How are you doing?
I enjoyed the football game last night.
That was. All right.
I know. Defenses.
This meeting of the State Board of Cosmetology and Barber Examiners is now in order and opened. Ms. Roxana?
Thank you. Good morning.
Good morning.
Today is Monday, February the 8th. I will do a quick roll call, and we will get started. Ms. Kelly Barger,
Present.
Anita Charlton,
Present.
Ms. Nina Coppinger,
Here.
Mr. Bobby Finger,
Here.
Mr. Frank Gambusa, out. Mr. Ron Gillihan,
Here.
Ms. Brenda Graham,
Here.
Ms. Yvette Granger,
Here.
Patricia Richmond,
Here.
Ms. Judy McAllister, Ms. Mona Sappenfield,
Here.
Ms. Amy Tanksley,
Here.
and Ms. Diane Tiefenteller.
Here.
Thank you. Everyone is here, so we will, is that the minutes? Thank you. I will turn the floor over to Chairman Gillihan.
Our next order of business this morning is to recognize some of our guests here. It's normally our custom to recognize any schools that are present. Do we have any schools represented or students here? Could you stand up? Wow, a good crowd of folks. What schools are you from, if somebody would just tell us? Miller Mott. All you folks over here from Miller Mott, thank you for coming. We appreciate it. Where are you folks from? White House High School. Okay, great. It's great to have a public school here. Thanks for coming in and seeing how your board works. Welcome. Okay. Nice to have you here this morning. Thank you. The next order of business is the approval of the December 14, 2015 minute meetings. Do I have a motion?
Make a motion to approve.
A second.
We have a motion and a second to approve the December minutes. All in favor say aye.
Aye.
Opposed say no. Motion carries. And now we're down to the adoption of the Robert's Rules of Order. Do we have any questions on Robert rules? Okay. We would need to have a motion to approve the acceptance of our use of Robert's Rules of Order.
Make a motion to accept the Robert's Rules of Order.
Second.
We have a motion and a second to accept. Those in favor say aye.
Aye.
Opposed say no. Motion carries. Now, Ms. Roxana, we're down to the election.
Thank you. Thank you very much. So it's that time of year, and we're going to start with any nominations that the board has, and we'll start with the chair. That would mean that the chair that gets nominated and voted on today will hold until the next February meeting, and then we will do vice chair, if that sounds good with everyone. And while we're at it, we can probably discuss the subcommittees, if this is a good time. If everybody's happy with the subcommittees, at least we'll document that we're continuing the way they are. If we want to add or take away, that'll be a good time. So I will open the floor for anyone that wants to nominate a chair for our next year.
I'd like to nominate Ron Gillihan for chair.
I'll second it.
Others? Okay. Do a vote? Yeah. If we can do a vote, we've got one nomination for Ron Gillihan as chair for the board, and I will do roll call again. If I could start with Ms. Kelly Barger,
Yes.
Ms. Anita Charlotte,
Yes.
Ms. Nina Coppinger,
Yes.
Mr. Bobby Finger,
Yes.
Mr. Gillihan, skipping,
Abstain.
Ms. Brenda Graham,
Yes.
Ms. Yvette Granger, Ms. Patricia Richmond,
Yes.
Ms. Judy McAllister? Oh, she's not here, I'm sorry. Ms. Mona Sappenfield?
Yes.
Ms. Amy Tansley?
Yes.
Ms. Diane Teefatiller?
Yes.
Okay, so we have unanimously Chairman Gillihan, one more year. Thank you
Thank you very much.
so much. Okay, and we have Vice Chair. Do I hear any nominations?
Nominate Kelly.
Second.
Okay. We will go through the entire process a little bit quicker. Ms. Kelly Barger.
Abstain.
Stay. Anita Charlotte.
Yes.
Nina Coppinger. Yes. Bobby Finger.
Yes.
Ron Gillihan.
Yes.
Brenda Graham.
Yes.
Wyvette Granger.
Yes.
Patricia Richmond.
Yes.
Mona Sappenfield.
Yes.
Amy Tansley.
Yes.
And Diane Teefatiller.
Yes.
All yeses. Very good. Thank you and congratulations, our vice chair. On the subcommittees, currently we have 2 subcommittees that meet every week, and they are the complaint committee. The complaint committee is made up of Mr. Bobby Finger, Mr. Frank Ambusa, Ms. Amy Tansley, and Ms. Diane Teefatiller. Any changes, thoughts? For the committee to be able to hold the session, we need always 3, and I think for the most part, that has worked out, and we've always had 3 in attendance. And no one that's on it saying they want to be off of it, so.
Do we have anyone that wants to volunteer to be member or a fill-in member in case, a backup member, in case someone has to be absent?
Or-
Come on, who wants to hang out with us at 8 o'clock?
Brenda. You gonna be the one?
You're already there, honey.
Three.
He has 4 right now, and Ms. Diane Teefatiller is the chair for that committee, so.
Because reciprocity, we only have 3.
Yeah, so if we want to leave that one alone, if the board is good, I will put that it's staying the same. And Ms. Teefatiller would still be the chair. Okay, and let's look at the reciprocity committee. Currently, we have 3 members only. It's Ms. Nina Coppinger, Chair Ron Gillihan, and Ms. Patricia Richmond.
Yeah, we might need
Need a
some
fourth.
more.
One more. One more.
Brenda?
Brenda, you're the newbie. You get broke in good.
Is that one of those when you're not at the meeting, you get appointed?
Yeah. No, it's not bad.
As a full-time or as just if someone's absent?
Full-time,
Yeah, it would be nice to have 4 in case.
in case
yeah.
somebody's not here
8:50.
because then that
Yeah.
messes.
We had discussed early on rotating the 2 committees, but I think that gets confusing. If we do rotate, the folks would come in at the wrong time, and then it'd be hard for the office to always know when to tell people that have a complaint or reciprocity to come in. So we've kind of set it, probably the complaint committee doesn't love it. They're the first group in. They get here right before 8, and they have a quick break, and then we start at about 8:50 with the reciprocity committee. So it would be that's something we're going to have at every meeting.
Sit on more than one?
Oh, yeah.
I don't care to.
Sit on both? Okay. Thank you. Okay, that works.
Take that.
Absolutely. Thank you very much, Diane. And then the chair for that one is Ms. Coppinger, so that would stay. Okay. The Rules and Regulations Committee that we've done, I'll leave it up to the board if we want to discuss it now. We currently aren't having meetings because I think we just went through the process. So we can let it go until we see the time to reconvene.
I don't know that we have any huge issue that we have to address right now, so let's, if it's okay with the board, let's let that one hold for a while until we need to bring it back in.
We get a new list.
Get a new list.
Yeah.
And a lot of the things we incorporated last year with the best practices and stuff like that, we're starting to look into those as well. Okay.
Perfect. Okay. All right, so on your iPads, we will start with the legislative updates. There have been 5 bills so far that have touched our industry, and they're all before you on your iPads. I would also have no problem emailing them to everyone after the meeting. The only thing to always keep in mind with these bills, as you've seen going through previous sessions and some that haven't, I'll be happy to answer some questions. Laura will also, she's been doing fantastic keeping up with these, is once we present them, literally while we're speaking right now, they could be going through a change. So you just have to keep that in mind, that these are living, changing almost daily. Any amendments to these, we will present then at the next meeting. So anything that is on here is as of Wednesday, when I kind of cut off and put it down. I'm going to start with Senate Bill 2324, also which is also House Bill 2315. This requires continuing education. This bill is creating a new requirement upon cosmetologists, manicurists, natural hairstylists, and estheticians who obtain an initial license after July 1st, 2016 to complete 16 hours of continuing education. Every 2 years with the renewal cycle, we hope. So, failure to provide proof of this bill within 60 days of the anniversary date when the licensure would automatically become invalid. So they must provide proof of this. The board for good cause may grant up to 1 year extension to obtain continuing education credits. The board is also granted the authority to establish a scholarship fund. They're also been given the rulemaking authority to carry out these provisions. For rulemaking purposes, this bill is effective upon becoming law, and for all other purposes, it takes effect July 1st of 2016. And for those that were on the board last year, if you remember, a similar one like this went till the very last minute.
With the continuing ed, we're envisioning this as such that they're going to be attending similar type conferences that instructors already have to do.
Correct. We envision that they would still be approved by the board.
All right.
And so if it becomes law July 1st of 2016, that first group of people that need to renew have till 2018. So we have about a year and a half window or so. I mean, obviously as quick as possible, but we really have that time span to start reviewing applications for folks that are providing this continuing education, that they meet the 16 hours that, and then we'd be approving those at the board meetings unless we establish a process at which there's an application and as soon as they fill it out, we're good with, approving them. But that's going to require a big pool of educators or seminars.
If that happens to pass the legislature in this go-around, as it's written now, the continuing education is designed specifically for educators. So it's going to be actually a different, probably, curriculum.
Correct. Oh, yes.
That we'd have to
Yes.
look at, so everything's just not all over the board.
Yes, yes. Different needs. Later in the meeting, we're going to present a particular group that discusses nails and the medical side of things, and those type of sessions may be greatly advantageous to our licensees that not only are looking at products, but things along the sanitations and
One of
things
the things
really
that we've really recognized in aesthetics, that many of the credit education classes that are offered in nursing, the estheticians have been invited into those sessions as part of certification and training to work in physicians' offices. And I just see that really exploding in the state, and estheticians are attending, and it's great that, those 2-day sessions where we're getting 6 and 9 hours of credit education, it'll just be really great for the field. Mm-hmm.
Okay, so I'm going to go on to the next one.
Can I add a question?
Yes, yes, Mr. Fingers.
I've noticed that it didn't include barbers.
That's correct.
Is that,
Again, these are coming from the legislators, right? And so they've just written this for the cosmetology folks. Did we ask for an amendment to include? No.
So that's a great point. Do they take our recommendation? Is there a feedback opportunity?
The board can, if you vote on it, you can adopt a position or a statement, and I can. But that's the process. So.
So anyone licensed before the July 1st is grandfathered in, they don't have to do it?
That's correct.
Okay.
But Mr. Fingers is absolutely right. It doesn't include the barbering code at all. And so,
Does that also adjust for renewals later on, or is it just anyone who becomes licensed?
just
Is this-
becomes,
okay.
right. So anybody prior to that date would not
Grandfathered.
need to take it. I foresee folks still taking it because the shops and the salons that employ, a lot of would absolutely have the right to say, no, everyone that works here is going to need to do it, not just the new folks. So I do think our numbers of those needing it could increase with this versus just the people that started being licensed in 2016. But as Laura said, I mean, if the board wants the language added for it to also be master barbers, we can definitely try.
We're also seeing the risk assessment managers with our insurance policies are requiring certification. So this will be really great.
I have a thought that since we're trying to combine, we've combined boards, we're trying to merge as many rules as possible. I don't know why a barber would be exempt from this, really.
Well, it's probably like with the apprenticeship, they try it on one side first and then push it through the
Okay.
other side. Maybe the board can be thinking about this, and if we want to adopt something as a board to recommend that it would apply to all the crafts, that's something that certainly deserves some consideration, and if they're just looking for any input from us, maybe that's how we could give it to them. But
I've had legislative discussion on this bill, and I think initially, like last year when it came around, there was a concern with getting it passed because anytime we do 16 hours of education, it's going to be a fee imposed on that licensee. So I don't know if that's relative to any segment of group, but that was certainly part of the discussion.
Well, I know the hair show in Alabama, they always have it set up where you sign in, like if you're from surrounding states, and getting your hair show ticket includes it, so it's no extra for that, and you get
they do it all
credits for that.
Continuing ed in
Wonderful.
different formats
Yeah.
and trade shows.
Yeah.
I'd like to recommend that we include barbers in this as it moves forward. Is anyone dramatically opposed to why we wouldn't want to at least ask for that?
Bills are amended all the time. I don't see where that would be.
We can
The
just
only
adopt a
issue-
position.
Yeah, the only issue may be that code has to be open, so it's already too late, am I right?
Open that
To
code.
open a brand-new code. So if 62-3 hasn't been open for this, it wouldn't be able to be done.
Where
But
is it
asking-
on the legislative floor right now? Is it in committee or is it going to the floor? Do you know?
I don't.
I would
Okay.
assume at this
Level.
point it's in committee,
it's
because
passed,
all
yeah.
of the bills had to be opened. If you want to adopt a position as a board, you have to vote on it. I don't think this bill specifically could be amended to include 62.3, but as you scan through, you'll see that 62.3 has been opened up many of places. I don't know exactly how it will be taken. I don't know who, I really just don't know. But I do know that the board can adopt to take a position, and then I can send that information
I
to
think
the
if the board,
legislature. And it does hold a certain amount of weight. But sometimes it's kind of like what Mona's talking about when the legislatures are discussing bills on the floor. I could not possibly predict what they will think is necessary or unnecessary. But if you want to vote on that position, that is something you're absolutely in your.
something to think about is that, through the processes of these legislative actions and these bills, if the board is in agreement that the code would be changed with this bill, I think adding the amendment might impede something that we already agreed on because of the process. I mean, the legislature is really, moving forward this year. They're hoping to get out a little early, I think. But, maybe we could adapt a position of a future, like introductory
Would be
with
in
the
favor
bar,
of this.
that we would be in favor of it if it was something in the future. But just through that legislative process, we wouldn't want to be, we don't even know how this is going to work, even though we're really in agreement with it. So maybe think of it as a future prospect, so that this bill will, something we agree that's good, will move forward through that process, which is difficult enough. Yeah.
We don't want to upset the apple cart and upset what they're doing now, but
Right.
if we
It's a
can,
concern. No, I
if we
I
can
don't
do
know
anything
that
to.
it would. It would just be a statement.
Could the statement be that our
So the
our
statement
stance?
can be where the board is open to including barbers in the future. The statement like it to be
I
now.
like that statement. We would be open to it. Yeah.
Now or in the future?
We need to make a vote on that? Would it be roll call? Do we have a motion that the board would adopt this position, that we would like to see the barbers have the same continuing education requirement, not just barbers, all the crafts, have the same continuing education relative to theirs?
I'll make a
individual crafts?
motion.
A second.
Second.
Is there any other discussion? All in favor say aye.
Aye.
Motion carries.
I'm gonna read back the statement just so that I'm clear. The board's adopted position on Senate Bill 2324 and House Bill 2315. The adopted position is that the board is open to including barbers in the requirement for continuing education now or in the future.
Because cosmetology is already included, all those crafts are in there, so.
If it passes, yes, the cosmetology is already included, so.
On the barber side, while it's seldom used, there's still the barber technician as well, so the barber crafts.
Barber professionals.
Okay, so the next bill is Senate Bill 2374, which is House Bill 2373. This is requiring, I think I've got it listed wrong. This is kind of a cleanup bill at this stage. It makes several changes regarding the cosmetology and the barber licensing. It creates greater flexibility regarding the hours taught per day and maximum weekly hours for cosmetology and barber schools. The bill decreases licensure requirements for schools by only requiring that schools submitting copy of a contract that is for a new school and will be used to not provide the 20 student contracts. The bill also provides various revisions for clarifications regarding activities defined as cosmetology, along with the licensure of natural hairstyling and natural hairstyling shops. This bill creates 3 years experience requirements for master barber instructor license, along with 300 hours of instruction as opposed to the 450, making it the same as the cosmetology, applying only to applications submitted after July 1st, 2016. Lastly, the bill allows the board to delegate the administering of the master barber theory and practical exam instead of it being under the board as the current bill has it. There's a part in the law that says that the board controls the exams as opposed to letting us delegate it to PSI, which is what we do. So it would clarify that language. This bill takes effect July 1st of 2016. And I'll let everybody take a
To
look.
note, am I
Yeah.
reading this incorrectly, but it says in several places July 1st, 2017?
Page are you on? Or
I'm on
point?
page 6. I'm under sections E, under 1, and under 2A. Just a consistency question.
That or not.
Oh, that is an attempt at a grandfathering clause. So what they're trying to do is cosmetology instructors, we had a lot of cases where someone had gone through schooling and then the bill passed, so they had gone through the schooling to be a Cosmo instructor. They didn't have the 3 years experience and now they're back. So that was an issue. We gave that feedback. This is pushing that requirement out another year so that after the bill passes, anyone who's currently in school isn't going to be stuck in that same way. But by pushing it out that way, everyone knows after it passes, and then going forward, that would be the requirement.
Fair enough. So folks who are not currently enrolled
Yes.
or thinking about being enrolled know the new requirement that without that experience, they will not become licensed. Okay,
Idea is to give anyone currently enrolled
fair enough.
like a fair shake, basically.
Yep.
The bill itself still becomes effective 2016, but since the date 2017 is within the bill, that specific part of the bill comes into effect 2017.
Thank you.
I had a question on the very beginning of this one. The 8 hours a day, 40 hours a week, up to 10 and 6, is that, again, for both sides, for Cosmo and Barber, or is this just for the Cosmo?
Yes. It starts with 62-3, which is the
Okay.
Barber, and 62-4 for both.
Okay.
So they would be consistent, which last year is probably what was meant to happen. But we've been hearing from schools, and the board has had to grant some extensions for those schools that have 10-hour days, that it's really taken their flexibility away.
Would that also, either within our rules or this, mean to adjust that 1 hour per day of attendance requirement? Or as some Cosmo schools now do 8 hours in one day rather than 1 hour each day of the week? I didn't see that language in here.
You mean of the theory?
Oh, the theory class.
Theory, yeah, it's not touching on the theory.
Okay,
That
it's just the
10% or
hours
1 hour,
altogether.
it's just number of hours, right,
Okay.
right.
Required hours.
You can only get 8 hours per day.
They can go to 10. 10 and 6.
This has been going back.
Okay, I'll move on to our next one. This is Senate Bill 2594, House Bill 2496. This is denial for licensure of a felony conviction, and this particular bill replaces the language in numerous professions allowing denial of a license for a felony generally, and instead requires that the denial for the felony determined by the agency to reflect the applicant's fitness for that profession. Specifically, TDCI, the Department of Commerce and Insurance, licenses are affected for barbers, surveyors, soil scientists, and exhibitors of license for fireworks. This amendment to the barber statute, which is the one that we're concerned with, removes the limitation that a felony must have been within the preceding 3 years. This would be just like the cosmetology. This bill takes effect upon becoming law. The bill is referenced in the Cosmetology Act, Tennessee Code annotated 62-4, but not in the Barber Act, the previous round. So this would make them both the same. Schools have been doing really well with this. We've changed the PSI question and sent it out to where PSI should know that if it isn't within the last 3 years, they don't have to block a student from testing. We've seen, well, the board has seen last meeting, I think we only had one applicant. So it's made a difference. But
Done today.
we're not there yet.
Okay.
But we have less than we used to, so, yes.
Spoke too soon.
No questions?
I want to explain something about this rule real quick before we move on. Language that directly affects barbers says that the only felony convictions that are going to be considered are going to be those type of felonies that the board determines bears directly on the person's fitness to practice competently. So if this passes, that means for barbers, at least, the board will have to, either through a policy or possibly rulemaking, determine which types of felony convictions the board thinks bear directly on someone's ability to be a barber. And then going forward, any felony convictions that someone has on those specific crimes are the ones that will be brought to you and be considered. That's all.
So that would be through our rulemaking process?
I believe it will be through
Okay.
rulemaking or possibly a policy. I would have to double check what the proper procedure is there. But this will be a little different than what they did with the cosmetology last year. Because last year they gave a definition, they said moral turpitude. So that that was kind of funny because it's unclear and it's hazy, but that is technically a legal standard, so we didn't really have to come up with a policy. This just says as determined by the board. So the board would determine what type of felony convictions they want to see so that they consider probation or not.
That be part of the 2016 agenda after, if it
That would have to
passes? Okay.
Okay.
The next one is short and simple and sweet. It is Senate Bill 2490, House Bill 2499 regarding extension of time to change address. This bill increases the time in which a licensee is required to provide the program with a change of address from 30 days to 60 days with the Board of Cosmetology and Barber Examiners. The bill takes effect upon becoming law. It is referenced in Cosmetology Act of Tennessee Code annotated 62-4, but not in the Barber. And so last year's cleanup, the large cleanup bill added the 30 days for anyone that moved. But again, this is only changing the cosmetology code to 60 days. And the last one that we have so far is Senate Bill 1536, House Bill 1582. This is the extension of the board sunset. The bill extends the sunset of the Board of Cosmetology and Barber Examiners until June 30th, 2018. It requires that the board undergo question and answer review by the controllers in 2017.
I recall they granted us a provision that was just going to be a review instead of a full audit.
Correct. And then hopefully the remaining 2 years. So that is exactly the case. Okay, so I will email these just if everyone wants to have them. I'll also remind, yeah,
On the
absolutely.
previous, the 2490 with the address change, it being only cosmetologist, is that a deal breaker for y'all not to just include the barbers as well if they're two different?
To be honest with you, so far, no one has contacted us because of the bill to change their address. When our field inspectors go out, we tell them now in general that the board office, you know, the statute requires the change of address within 30 days. Yes, just like the other one, if it included the barbers, it would make more sense. But I don't know, this one is adding the time frame, so I don't know that we can do anything with the barbers since it's not ending it from 30 to 60, and it was never in the code for the barbers.
We had a big issue with people not renewing or not changing their names timely.
Oh, it's huge.
Okay.
Yeah, our return mail is, we've actually increased what we pay now for postage. We no longer pay the state postage because of the volume of renewal license, renewal forms that come back. So we're paying the normal standard postage for 2,000 to 3,000 renewals to go out each month. But now, if they've provided forwarding address, at least the postal system will forward. In the past with the state rate, it wouldn't forward. So we would throw away hundreds because there's no way to change the address and resend them. We just, with our volume, we can't. Licensees do call and say, you never got it to us. My training to our staff is, it is your responsibility to renew timely. We do the courtesy of mailing renewal forms to you, but it is nothing that the board can guarantee is going to reach you because our folks do move often.
I think everybody should be pretty well familiar with the online system anyway, so.
Should. The renewal forms, if anyone here has not renewed lately or isn't familiar, it actually just addresses renewing online. We don't want paper, we don't want the checks, and it's not that we don't welcome and want it, but the renewal online allows the license to go out almost immediately. Coming into the building delays it just from the number of people that have to touch it. So there's no doubt that everyone should. So that renewal form starts out with, here is the great new online system, here is the website. It's much more secure. There is no fee involved anymore. It used to be $2 and change, depending. So, and very soon, we're gonna even be doing the brand new application to a new shop, to a new school, to a new licensee, all online, just to keep some of the paper volume down, because it's so intense. So yes, to answer yours, the changing address online should be really simple. But you'd be amazed. We actually hear, no, I've moved 3 times since what you had 2 years ago. So the likelihood of our things reaching them is not that great. Okay.
there a bill that said something about a scholarship?
Yes, so the
Determine
first
the-
one, it was on the
Oh,
one
it was
for
on the first
continuing
one?
education.
Okay.
And it says that the board will have the authority to establish this. So that is one of those things as well, if it passes at the end. The new licensees that start July 1st, 2016 will come on board. So we will have to start having those conversations of where that money pool would come from, how we generate it, whether it's from the seminars that are going to be created, those kind of things.
That a logistical nightmare?
I know that at least one other board does it, so when this passes, if it passes, then we are going to get their feedback, their idea on how they do it, and go from there.
Is it the architects? And does architects, don't they have a,
Architects and the contractors board all have scholarships. So it would be new to us. We'd have to kind of learn, go from what they've done that works, and then go from there.
Scholarships are not easy to administer.
Not mandatory. It
Okay.
says it gives the board the
I
authority to
got
do
you.
it.
I like that.
So if you discuss it and think it's not possible,
And it wouldn't be day one, you know, that's until they're ready to renew, we have some time to approve sessions and to really think those things through, and then think about when the scholarship can happen, and so that would be good.
Can I just say something to the board? But you may all be aware of this, and I don't know, I'm just like I wake up in a new world every day. I'm like, what? But one of the state representatives from my area, and this was in the newspaper, so it was public knowledge, he introduced, it was a caption bill, and it had to do with the safety of bike helmets and wearing bike helmets properly. And then it was amended to be a bill about the ways that teachers' unions can collect payments from teachers. Like, as in, they didn't want them to do direct deposit, not direct deposit, the bank drafts, because it was making it too competitive for some other teachers' unions. I'm telling you, the original bill was about bike helmets. So daily, I go to the legislation that deals with cosmetology. I do it by subject and just pull them up and look at it and click on amendments, because we have been surprised before at the last minute. So keep an eye on it just to see what's going on, because they really have a way of doing things up there.
And every one of these bills can change many times. So you would go to the Secretary of State. It's really a good website, right?
Oh, it is.
And it's easy to find.
real
and you
easy.
Put in the word BARBER COSMO. It'll flag the bills. You can follow them, and I highly encourage everyone to follow them, because it gets really busy at some point. I mean, these are the bills that are going to keep changing until they're finalized. And then I'm going to present them to the best that I can. Thank God for Laura. She'll explain them, and any questions that come up. And if the board is concerned with any of them, we've got, the March meeting, obviously, and then April, we can always ask someone to talk to us about them if we get to that point.
Want to recommend on that bill about the address change that we include barbers or all of our licensees, like we did on the previous bill?
My concern with that one, is I don't think the law that changed it last round that cleaned it didn't add the change of address to the barbers at all. But I can definitely look into it. Would we need a motion right now if it did? Because this one's changing it. So if it didn't even add it to the barbers.
Oh, it can't be
It can't
changed.
be changed, right.
Okay.
But it could go in as a 60 days for the barber code.
Well, I was just
If we can
curious
look at
as we
that.
talk about
Yeah.
just purely for consistency purposes, if our feedback is always start thinking of this
Oh,
as
yeah.
one board versus two, and they're all separate. It just seems like a nightmare in your office if every licensee has different requirements.
And it gets complicated for them too, because we have people who are dual licensed and
Right.
multiple licensed.
So I've got 30 days here and 60 days here and all across. Yeah. Motion would be that on Senate Bill 2490, our position is that change of address would be consistent for all of our licensees.
Barber professionals, all the licensees across the board. Do we have a second?
I'll second.
Any other discussion? All in favor, say aye.
Aye.
Motion carries.
Laura, is there a chance that they could amend it to be that, to say that?
Talking about how bills are opened and then changed into something completely different. I review all of these bills and give my impressions, and then my supervisors read them, and so on and so forth. I see this bill as opening up the entire cosmetology one specific change. That might be entirely what these senators and representatives wanted to do. I don't know that, though, and I don't mean that to be
Right, I know.
disrespectful to any representatives. That might be exactly what they wanted to do, and in that case, there's absolutely nothing wrong with the board having a position that if we're going to require it on one licensee, one license type, that respectfully the legislature attempt to make it the same. I can pass that along. I think it probably holds different weight with different representatives. But some of them I think would probably be appreciative to know that the board supports or has comments on what they're working on.
I think really we're just trying to speak with one voice here on all this. And where we
Everyone
have unity,
equally.
it really helps everybody where we have unity.
And this may be the one caption bill, because it opens it completely. And I don't, increasing it from 30 to 60 days doesn't, I don't, is kind of odd, but it could be that was what it's intended, just like Laura said. So
Placeholder.
we'll find out. Yeah,
But we can only comment on what's been published,
correct.
not what we
As
think
of
might
today.
be added
Because we
at
have
a
no
later
clue.
time.
Right. So by April, we would be able to say this is what it's amended to, or really that is how it's staying, and we go from there.
I think it's probably,
Department, we have a legislative team, and they also monitor these bills. So we should know right away if any of the bills affecting any of our programs have amendments. I can most definitely take the two adopted board positions on the bills that we discussed and pass them on to our legislative liaisons, and they will get them to where they need to go.
I think it's probably important to note that these are already submitted, they're already in the soup, and, if they're gonna make some changes in there, they're gonna do those things. And our positions we've adopted may not change anything, it may, that's just letting them know how we feel. I
And
think
since
that's
we're
fine.
a combined board now, it only makes sense, we're trying to be consistent. And that would be the argument, on both of them.
Sounds great. We are going to go ahead and start with our appearing before the board. And on your iPads, you are on page 15. This is a new school application. It is the Institution School of Cosmetology. And Dr. Joyner is here to join us. I'll let him come up before the board. Sure that speaker is pressed, okay?
Hello, Dr. Joyner, thank you for being here, we appreciate you coming, and welcome, and tell us, if you would, just a little bit about your school.
Good morning. It's so good to be here with the board this morning. I've been in, if I can tell you a little bit about how I got interested in a school, I've been in the cosmetology industry since 1999, and I'm the owner of 9 salons, and I saw the need for a school. I saw so many careers being short-circuited, and then I kind of did a little survey in the Shelby County area, and I really saw that there was a need for a school, and a school to be run like a school ought to be run. And that's why I was interested, and that's why I applied for the institution.
Thank you.
You have on your iPads the full application that Dr. Joyner presented. He mentioned the school is located in Memphis. We have the payment, the floor plan is there for your review. We've received all 20 signed student agreements. The school has one instructor starting out, Miss Patricia Moten. The agreement is on page for the students 18 and 19. I did ask Dr. Joyner to explain the refund policy. I couldn't see it clearly pinpointed. And of course, these agreements are tentative, so he was going to explain that piece for you.
I
and-
brought one with me.
Oh, okay.
I thought I emailed it to you. Let me give it to you.
Is this a revised one?
Yes, ma'am.
The school has, yeah, and I've gone ahead and passed the paper around for everyone to be able to review. That would be the refund policy for the school, and it'll be part of the agreement once they finalize, and it looks like it falls in line with what we get.
Joyner, on, well, our page 34 of 181, I don't know where it falls in your plan, but the topic is skin disorders and diseases. Is that a caption of curriculum for the cosmetology program, or you be offering the aesthetics program as well?
I didn't understand you.
Are you offering the aesthetics and the nails program, or is the curriculum presented today for the cosmetology segment of ours for skin disorders and diseases and also the nails? I mean, are you doing just the cosmetology school?
Just the cosmetology.
So are you segmenting, having
We're doing
aesthetics?
nails and waxing.
Aesthetics.
So you will have aesthetics?
Yes, ma'am.
Too?
Aesthetics, yes, ma'am.
Okay.
I think Ms. Sappenfield's question is, are you going to offer the separate curriculums, cosmetology?
Step up curriculums, cosmetology first, and then we're gonna step up as we go.
Are you offering manicuring all by itself?
No.
No,
we-
just cosmetology?
Just
Okay.
cosmetology.
Okay.
Okay.
I was just,
Are you wanting to incorporate that later?
Ma'am.
Are you wanting to incorporate a nail, just nail
Yes,
thing
ma'am,
later?
we will.
Then you might want to suggest getting approved for all of that at one time.
And the license covers all of it?
All of it?
Yeah,
Okay.
we don't, it wouldn't be
Separate it out,
considered
okay.
if it was the other way around, if he was being approved just
Right.
for manicuring or just
Right.
for aesthetics. The floor plan right now, let me get back, hold on. I think actually lays out,
It lays out the manicure, pedicure, and
right, because
aesthetics.
the curriculum cosmetology covers it all. So it is all laid out to where if he offered the separate classes,
As I say,
he could just take off with them,
okay.
right?
So make sure he's covered for them.
Yep, it has everything.
On your enrollment agreement, it mentions the weeks of instruction starting in March and ending in December. That's just a placeholder. You're not only going to start in March, correct? You'll start classes every month, or?
Every month, yes,
Okay.
sir. Mhm.
Dr. Joyner, I wanted to ask you a question about the refund policy. I see on there it's stating about how the student is charged, but I was unclear on how the refund would be dispersed to the student if that occurs.
All payments are due payable in advance, full-time 15 hours of cosmetology students are attending evening classes. It will be refunded on if 15 hours are not completed, an 18-month student will be charged $5 per hour until the 15 hours are completed. Once you are enrolled in the school, you have a certain amount of time because it's going to be paid on a gradual basis rather than paid up front. If paid up front, we will refund it according to how long they've gone to school and what's left on their term.
I guess that's what we were trying to see clearly.
Yeah, because right now, as I read it, it just seems to explain how the student is being charged, not so much as to how the student would be refunded based on the hours and graduation and things of that nature that you just mentioned. It's not clear on the form.
On the form?
Yeah, I understand what you're saying, but it's not clear on the form in that way.
Do you agree?
Doctor, what we normally see is a schedule that will break down a percentage of hours scheduled or earned compared to some percentage of tuition owed. And
We can modify this refund policy to include that, and we will.
Yeah, that's what I wanted to bring to your
We
attention.
will modify it, and we will get a copy to Ms. Roxanne as soon as we make the modification, and we'll make sure it's to her satisfaction.
Right.
I have one question. And I only bring this up because this has been a year of unprecedented of closing of schools. And I'm quite familiar with doing a financial analysis on what it actually costs for tuition. And I don't know how you're going to run a school with a total tuition of $2 an hour and charging a student for this for this curriculum $3,000. I mean, I just think that's very lean unless you own the building and your family's working for nothing.
I'm sorry. I've been owner of the property ever since 1999.
Okay.
So the property that the school is in is paid for. Also, I have enough money to operate the school for at least 2 years if I don't take in a dime.
I see.
So, and I knew that on the outset of even starting the school. I knew that I wouldn't be able to get financial
assistance
grants and stuff like that until the school gets certified. So I am equipped and I am in position to keep the school open for 2 years until I can get our certification, and then we can secure grants and scholarships in order, and the tuition will increase. But the reason for this is specifically to get students to come, to run a first-class school, to cross every T, dot every I, make sure my paperwork is in order. And I'm familiar with state. I was in daycare for 40 years, so I'm familiar with all rules, regulations, and all kind of stuff like that.
Oh, I'm sure.
And I really want to make, whenever the inspectors show up and they want to see the paperwork, there it is. And matter of fact, we're going to have it all on computer, plus we're going to have a computer copy and a hard copy. So we want to make sure that we do it right. And one of the reasons that I wanted to open a school is because I saw many schools not doing it right. My son went to school, and it wasn't done right, which I won't call the school name, but I wanna make sure it's done right.
Thank you for
And
your
I'm gonna do all I
explanation.
can
Thank
to
you.
make it right.
Are you a master barber or a cosmetologist?
No, I'm not. I just been in the industry
Okay.
without a license. You know, I'm not a cosmetologist. But I've been around, and I've seen it since '99, and by me being I rent out shops, and by me noticing what goes on in them, then that sparked my interest in the school.
I had, I think, another question here on your enrollment agreement, just a simple thing, I believe. you're charging a registration fee and an application fee on there. There's nothing wrong with that. But as I read a little bit deeper, in another page, it mentions that you're going to have a small down payment for evening students, or small payments, or excuse me, a small down payment, I think is the way you word it, for evening students. Is that going to also be offered to the day students?
Yes, right.
Okay.
Really, we want to make it affordable. Since we cannot get the grants and the student can't get the grants and come to our school, we want to make this program affordable so students can come, and they will encourage others to come. You know, and as the school grows and we earn our certification, then we can move on to other areas and other stuff.
There's a question that we have asked a lot of schools in the last few years, so we probably need to ask this one of you as well. In the unlikely event that you were to close, have you given thought to how you would have a teach-out agreement with some local other school, or how would you dispose of students in the event that you were to close for some unforeseen reason? What is the closeout plan for your school?
I think I'll come to that if I were to close, which I don't plan on it. But if I were, I would try to work out an agreement with another school to take those students that's enrolled. But I know we won't close for 2 years.
Hey, can I give you a word of advice?
Let's hope you don't close at all.
Oh, yeah.
Okay, you're going to be 2 years getting your NACAS.
Getting your federal
Ma'am.
approval.
Getting your NACAS accreditation will take you about 2 years. And then when you apply for the federal grants, it's going to take you probably another year to 2 years more to get your federal. So you're looking probably at 3 to 4 years before you get financial aid. It just takes a long time.
Well, I'm in a pretty good position financially
Good.
already.
Yeah.
So
I just
it's
want you to be
not-
aware it's going to take
Yes,
a little bit
ma'am.
longer than 2
I'm
years.
aware of-
to get
I've been in
everything done.
business for years and years, and I know you don't even make a profit in business for the first 3 years. So if you can't function for 3 years, more than likely you won't make it.
It's just it's a process.
And that has been my experience in business, that usually you open up a business. Matter of fact, you probably lose money for the first 3 to 4 years. And I understand
years.
that, and I understood it on the outset of the institution.
Yeah.
Do any other members have any further questions?
I have a question about the apprentice program. Are you going to offer that?
Ma'am,
The new apprentice program that the board is offering?
I'm familiar with the apprentice program, and I plan to incorporate that in my program. I would have to find out when they enroll if they want to be a part of apprentice program, or if they just want to be a part of the regular school program. So we will make sure that we got an understanding at the time of enrollment that they will be a part of the apprentice program or part of the regular college program. Now, once they enroll in either one, they can't switch.
Thank you. I was just curious.
All right, thank you, ma'am.
Roxana, is all the rest of the application in order for your office? Has
It
everything
is,
you need?
it is, absolutely. We've got everything. I was able to confirm the instructor, and I do believe that refund form probably came in and I didn't add it to your iPad, so I apologize. But yes, once he revises the refund policy to be percentages, just so that the board is comfortable with knowing what would be refunded back, like you said, I think we have everything that we need. With it being a new school, we are still recommending that a board member go along with the field inspector. So pending that, they would have everything.
Other questions? Do we have a motion?
Make a motion to accept.
Second.
We have a motion properly seconded to accept. All those in favor say aye.
Aye.
Those opposed say no. Ayes carry. Congratulations, good luck.
Praise the Lord.
Best of
Good
luck.
luck.
I am a full-time pastor, too.
Good for you. Good for you.
Ready to be inspected soon, or will you rather get back with me?
It will be, as a matter of fact, it will be ready to be inspected by next week.
Okay.
The school is complete, everything is in it, the furniture, everything, and we're ready to go with it.
So I
Will
will.
you send Jerry over there? Well,
Yes,
yeah.
Jerry will be going,
Yeah,
and
I'll
then
go.
you will go? Okay.
Sure.
So Ms. Sappenfield will be going with Mr. Biddle
Oh,
sometime
that
next
would be
week.
fine. That would be fine.
And I'll confirm and let you know the date.
Oh, thank you, ma'am.
Thank you, congratulations.
And I
Good luck
want to
and
thank the
much
board.
success.
Thank y'all for considering the institution.
Well, good luck.
Thank you.
We'll talk. Thank you very much. Okay, next on your iPads is a change of location, and I'm going to get us to the right page here in a minute. Oh, that was wrong. 80. On page 80, this is Sandra Academy of Salon Services Incorporated. Miss Sandra Clark is appearing before the board. Miss Sandra? Make sure that. As long as you press the red button.
Good morning. I'm honored to be here today.
Hello,
Morning.
how you
Good
doing?
morning.
Good to see you.
The board office has received the application and fee. The floor plan is presented before you, as well as the documents that are required, and I will let her answer any questions that you've got. And this school is also ready to be inspected soon, so we'll make sure to go over that.
This is just a change of location.
Are you expanding? And we are. That's great.
Good. Have you made any significant changes or substantive changes in your curriculum and things since you've designed your move?
No, our curriculum, we use the Milady curriculum at this time, and we are partnershiped with Dermalogica Institute for our aesthetics program. And at this time, we're not adding anything. We're just getting more space to be more efficient.
I see the cosmetology refresher course. Is that pretty common in schools?
A lot of people call to ask for a refresher course.
That's a course
great.
that we have got approved through NACAS, and it's just for a student who may have completed their hours somewhere but are struggling with the board. Then they come back and we do what we call kind of like a boot camp with those students to prepare them for the board.
Oh, okay.
Okay.
That makes sense. That's great.
A lot of schools do that, and since it's not for credit hours.
I got stuck on
okay.
that page too. I think that's a great idea. Yeah.
Make a motion to accept her
Second.
application.
We have a motion and a second to accept this application. Are there any other questions? All those in favor say aye.
Aye.
Motion carries. Congratulations and
Thank
good
you
luck.
all. We're super excited, and I appreciate your time.
And they
Thank you.
have already moved, you're in the middle of finishing the move, so they are ready to be inspected next week, is that correct?
Yes, we would like for our first day of school to be next Monday. Everything is moved except the classroom furniture, and they are still under classroom theory instruction at the present week.
I could
Would you?
I could go anytime.
Okay. I will go ahead and give Ms. Barger your information so she can contact you directly, and that way you can both work on it and whatever's convenient for you. Thank you so much. Perfect. Okay. Now we are ready for our applications for examination.
Put that in there.
On your iPad, starting with page 94, you have applications for Tiffany Asaza and Corin Ramsey. The applicants have felonies within the last 3 continuous years and are incarcerated. The request to take the Tennessee examination is submitted for the board to approve. The required information, disclosure from the student, and a letter of recommendation are all submitted. Upon your approval, an agreed order will be sent to each of these candidates with a 2-year probationary period, as is our norm, unless the board decides that longer is needed. Once you've reviewed the information, I will need a motion to be able to approve this.
Roxana, do you want to do these one at a time, or are we doing them all together?
We do both generally, unless there's a concern to address with the two.
Motion to move forward both of these applicants to test? Is that what we need to do?
Yes, that is correct.
Do we have a second?
Second.
We have a motion and a second to allow these 2 cases to test. Any other questions? All those in favor say aye.
Aye.
Opposed say no. Motion carries.
Next, we have an application to test as a manicurist from Lam Nguyen from Vietnam. Mr. Nguyen was previously presented to the board at the October 5th, 2015 board meeting, and the board requested he submit additional documents breaking down his educational hours. He has provided translated documents showing 648 hours completed in 2014. That is starting on page 108, and 109 shows the breakdown. The board would be approving him to take the 2 exams if this meets the requirements.
Make a motion that he take the exam.
A second.
We have a motion and a second to allow this applicant to take the exam.
On.
Is there any discussion?
Yeah. Why didn't this come before the reciprocity committee?
Well, our international applicants generally come in as this because they're really asking to test simply because reciprocity is the United States and U.S. territories.
Oh, okay.
On occasion, we'll get international applicants through reciprocity because they've filled out that form. And instead of just stopping them at that portion, at that part, and having them fill out a new form, we still always know that with our international, at least it's been the board's decision so far, that with international applicants, we at a minimum require the exams. Sometimes if the translated or the hours aren't there, the board could consider additional hours. But once the documents are there, they're hard to vet to know what the documents really are, but the exams, it's been the board's determination at least protect and know that they have the experience in the industry.
So all of his training and school was
All in Vietnam,
Vietnam?
nothing in the United States.
Okay.
That's correct.
Any other questions? We have a motion and a second on the floor. All those in favor say aye.
Aye.
Opposed say no. Motion carries.
We have an application to test as a manicurist. Ms. Diem Thai Tran, also from Vietnam. Ms. Tram has provided translated certificates of completion showing a total of 714 hours completed in April of 2015. This would be a similar situation.
Make a motion to approve.
I'll second it.
We have a motion and a second to approve. Is
Is
there
this-
any discussion on this one?
I'm just kind of concerned because I don't know if they understand the laws, sanitary laws here or not. I don't know
Well,
if we
they-
should.
That's why they
They're
would be
asking to
taking the
test.
exams.
For the test.
Okay. they're
They
taking
have
the
to
test,
test.
Okay.
Oh, yeah.
Approved for the test.
Okay, that's fine. Good.
Will they be working with an interpreter, or will we hear from them that they'll be taking this test 19 times? Or,
No, remember, we have the exam in Spanish and in Vietnamese now. So in
Good.
both of these candidates, we will be putting them through to test in Vietnamese because we can see from their documentation that's what they're needing. If it's any other language, then we still struggle sometimes. But here we are okay. So. This particular candidate marked that it's a reinstatement exam, but she has no license anywhere. So before we put her through, I will personally make sure that she doesn't have a license in Tennessee, and that she just marked the wrong box.
All those in favor say aye.
Aye.
Opposed, say no. Motion carries.
Next, we are on our miscellaneous part of our agenda, and we have requests for waivers and extensions. The first one is a request for waiver of Rule 0440-1-.10, requiring an applicant to obtain the original license within 6 months after passing the examination. Ms. Julie Littleton passed her practical exam in February of 2015. Under the cosmetology statute, the applicant must reapply for examination within 6 months after they were notified, unless for good cause. Ms. Littleton is 5 months past the required timeline. Her letter states that she called the board office, that she did not realize she needed the verification eligibility form until January of 2016, and the letter gives several other excuses. The letter from the board that you can see before you is dated March 26th of 2015, clearly attempting to reach her for the verification eligibility form. Emails and calls have also been incomplete with this applicant. We have no messages that she's been calling. I just want to remind the board that in her case, she passed in February of 2015.
She received this letter in plenty of time.
She says she didn't.
I'm not personally familiar with anybody who's ever called the board office that hasn't got
Not
some
gotten
kind of response.
Me neither.
I'm sorry, in my own opinion, is I
Yes.
just don't buy that at all.
No email or phone call, she said.
If we deny this, she'll have to go back and retest.
That is correct. My recommendation would be, given the time frame, that's the route we go. Her letter has no life-changing event that would have kept her, I think, from reaching someone at some point. But that's my thought.
I have a question.
Yes.
Is it your practice to email page 2 of the application to someone?
We email, well, we were, so
Okay.
I'll update the board on where we're at now. We call whenever we can, and 9 times out of 10, we get back, well, I didn't check my messages, didn't get it, no, you didn't call me. We email consistently, but emails can go to junk mail. But we email all 3 pages, because the verification eligibility, which is a federal form, it would just be wrong to start out with by just sending page 2, because it's not telling you what you're signing off on. And if you are a foreign alien, it's not giving you the option of what you need to send, so it's actually given us more work than it was even worth. So all 3 pages are considered one document. We have recently, or I have decided, we are not calling and emailing because we are failing so much with the calls and emails. It's time prohibitive. We're going straight to the letter. And although there's postage behind it, if we'd been successful with the calls and people had called us back or gotten it in, then we would continue. But it really is a minute number that respond to those calls and emails. So we are mailing the letters now almost immediately, where before the letter took a week to 10 days to go out because we were hopeful to have the feedback by phone or email. So, but the letters go out every time. And again, like anything else, if they've moved, we can't reach them. And many times a student has gotten settled into a new place after finishing because they're so we understand the moves. That happens.
The schools should be enforcing, you only have 6 months to get this done.
Exactly.
It should come back to the schools too.
Yeah.
Do we have a motion on this case?
Motion she retake her test.
Second.
We have a motion and a second to deny and have her retake her test. Without any further discussion, all those in favor say aye.
Aye.
Motion carries.
We have one more Similar to some extent, this is also a request for waiver of 0440-1-.10 requiring the applicant to obtain their original license within 6 months after passing the examination. Ms. Tori Steelman passed her practical exam in May of 2015 under the cosmetology statute. The applicant must reapply for examination if within 6 months they've not obtained a license or have good cause. Ms. Steelman is 2 months past that required timeline. Her letter explains the life events that have caused her the lack of being able to follow through. In the letter, she apologizes and takes responsibility for missing the timeline and having missed the verification eligibility requirements. What the board had allowed because of this verification eligibility is past the 6 months, I was given 1 extra month that we could waive. So she's really 1 month behind that as well, whereas it's the similar request. She's not missed it by quite as long. Her letter, again, does list the reasons why her life added to missing the timeline.
Takes responsibility for her actions.
Apologize.
Oh, and I can see that, because I know when my
We'll
father
have to
was
do the
sick,
same
you
across the
know,
board.
you get busy with them.
Yeah. Like we need to be the same at whatever we do across the board.
We've approved these on other
with
occasions.
circumstances.
I think the good cause is the key,
Keys,
at least
yeah.
where the board has drawn the line. And then the timeline, you know, if a year's gone by, I don't know that, like you said, the school would even encourage you to start working
Right.
and wait that long. So between the timeline and the good cause, I think is how the board has tried to make their decisions.
How late is she?
She is 2 months.
2 months.
So if in December she had reached us, then I would have been able to approve her. In January, when she did contact the board, it was already past the time I could have approved her, and we had no board meeting.
Have a motion or any thoughts on this?
Have a thought. We have approved people in, I believe, this situation who've actually presented medical records with the reasons why they were delayed. Would really hate to ask someone for medical records, but I just wanted to make that point, that we have approved people in the past.
There'd probably be privacy issues involved with asking for medical records, and these are not for her.
No, but I'm saying people have volunteered those
Oh,
before.
absolutely.
HIPAA's gonna come in and,
Yeah.
just kidding.
Yeah, her letter, right, her letter even mentions the doctor, I think.
I believe in the past, we have approved most of these. Most of the applicants have been very apologetic and have had reasons why they have been late. And we've approved, I think, all of them.
If we
Most
had
of
met
them.
last month, we would have only been talking about a few weeks.
Correct. That is correct with her. Yes.
What's the passing score, 70?
Yes.
She looks like she could stand and take it.
9.
It's just,
I make a motion to approve.
We have a motion to approve. Is there a second?
I will second that.
We have a motion and a second to approve. All those in favor say aye.
aye.
Opposed, say no. Motion carries. It is approved with 1 no.
Is the board okay continuing without a break? We're going to try to, in case the weather changes, wrap it up without lunch, but I'll let you all stop me at any time. Okay, a request from instructor Tiffany Wilson for an extension of a required continuing education hours. She has attended continuing education seminar timely since 2006. Pursuant to Tennessee Code Annotated 62-4-114A2, an instructor may request this waiver one time. She submitted an email explaining that she got off track and missed the 2014 session. Instead, she went in October 2015 and attended the session in Chattanooga. Her request is that the board allow her one-time exception and accept the seminar that she's already attended, so her license can go out.
Make a motion to accept the one time. That's what we've been doing.
Second.
We have a motion and a second to accept the one-time pass. All those in favor say aye.
Aye.
Opposed say no. Motion carries.
Next is a request for an extension of the 7 years to complete the instruction in cosmetology. Ms. Paige Norwood is requesting this extension pursuant to Tennessee Code Annotated 62-4-123. Students have 7 years from the original enrollment date to complete the required courses. The board may require a student to complete additional hours or for good costs. Historically, they've considered extensions of this time. Ms. Norwood has presented a letter explaining the car accident she had when that caused her to move out of state to Alabama. She is currently re-enrolled, and so the old hours, if you will, that go back to 2009 on her letter are about 96 hours. Her re-enrollment is 2014, so.
Have we seen her before? Have we seen this?
I
This
don't
has a
think so.
deja vu to me. I
Yeah,
don't
that
know.
sounds a little familiar to me.
Does
too.
it?
She's essentially asking us to approve those 90, approximate 6 hours that she took in 2009.
Right, because her anniversary for the 7 years for those hours would be July of 2016, and she will not get finished. So if the board, and the way the statute's written is she could lose all of them. So now that she's been enrolled, she's gambling with all the hours she's been attending, so.
Not just those 95.
Correct.
Does
Correct.
anybody else see that on the last paragraph, her plea is to grant extension or basically just use her second enrollment date?
Correct.
Would that mean not involve those first
That's correct.
95 hours?
That's correct.
Okay.
Because the way the statute's written, she could lose all had she not asked for an extension. So if the board is comfortable with granting her, she doesn't say how long the extension, so it could be that for life circumstances, she can't go full-time, so she may not get done for 2 or 3 years. It's not in her letter. So the
It's
board,
7 years from the 14 when she
right,
started.
if it's 7 years from the
Yeah.
2014 and she's okay with
Yeah.
that, she'd just be losing the 96.
Yeah.
Or your decision can be, yes, we extend
The whole.
the time frame
Hours.
and she keeps the 96.
I'll make a motion to extend the whole thing
A second.
to be done within the 7 years from 314.
Do we have any other discussion?
So you're saying that her second enrollment date should be considered? And
Yes,
she loses
starting
the
her-
96
No,
hours?
she can keep her 96 and
Oh, keep all of them.
keep
All of them and
her
use
new-
the second enrollment date.
Right, uh-huh.
Okay.
That's how we'll word it.
Any other discussion? All those in favor say aye.
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 Opposed say no. Motion carries.
Next, we have a little bit of a different request. I can't remember the last time we've had one of these. This is a request from Master Barber Ronald Fairs. It's for a waiver of his renewal penalty fee. Letter provided from Mr. Fairs explains that he came in person to renew on May 12th of 2015. His license had been expired for many years, so he owed a very hefty penalty for the barbers, the way those penalties are kicked in. The renewal fee at the time was $480. He says he asked how much he owed and believed that that amount would carry him way into the future. That $480, in essence, only carried him until June 30th of 2015. So he paid and expired the next month. And had moved, so of course he didn't get the renewal information. In January 2016, he was wondering about where the license was, and at that point, even though he paid the $80 to renew it, it was not enough because he owed $160. So he's asking the board for consideration of that $80 penalty, given that he really thought that when he came in person and paid, he was paying through for the next 2 years, when in fact he was really only getting current. It's definitely nothing I can waive. The board in the statute includes postmark dates, just for everyone to kind of know. So if an envelope is postmarked by that last day of the month, then we internally can waive those fees. Anything beyond that, when it falls on the weekend, if the computer goes down, if it gets busy and you didn't get a return call with the address, we just can't with the volume cover and waive all those, because it would never end. And inevitably, everyone waits for the last minute. So in this particular case, coming in person and paying so much opens a little bit of a different confusion, if you will, and in his case, the $80 makes a big difference.
I make a motion that we waive the $80.
A second.
All those in favor say aye.
Aye.
Opposed, say no. Motion carries.
Stop looking at me.
I know he will be very appreciative.
He's paid, that's a lot in fees.
That's a
The
lot
barber
of fees.
penalties
It is a
are
lot.
extreme
Brutal.
in those cases, folks. They add up fast.
See that? Crazy.
And this is one of the areas that with the new rules, when they go through it, it is going to become a normal
Students, do
penalty.
not let your license expire.
Do not. Okay, next we have, this is the second even odder request. It's a barber shop, Horns Creative Hair Designs. They are requesting consideration of a late fee given that the online system somehow mischarged them. I've personally looked into, along with my administrative manager, and reviewed the financial information for this shop. The shop currently owns $500 to be renewed. That is an accurate amount of what they owe. They were issued 2 complaints for working on an expired license in 2014, which totaled $500, and they made those 2 complaints right and paid them off. Mr. Horn lost his wife, and the change of that life event drastically affected his compliance with renewals and his business management. The shop that has been in business since 1992 had no prior complaints, was used to being current. Mr. Horn has been licensed even prior to 1992. Both he and his shop, again, had no prior complaints. After 2014 inspection, his daughter assisted him in paying off his obligations. The complaints were part of them. And then, again, his daughter went online to pay for the renewal of the shop. For reasons that I really can't explain, I've asked IT to look at it, as well as the finance main person. And so you've got, I think, here email correspondence from Ms. Kramer and I, trying to understand how this took place. But for some reason, the online process, when the daughter went to pay for the shop renewal, at that point they owed $300, and the online process allowed them to just pay $25, which it shouldn't have. So when the daughter finished the transaction and paid $27 and change, which is on page 135 of your iPads, she rightfully came to the conclusion that the shop was now current, and that's what the dad thought, and that's how they functioned. So I'm not comfortable, even though they owe another $500. The penalties imposed after that are just hard, given that they really made the complaints right, had no prior histories, went online to pay and make it right, imposing that kind of a fee when they thought they were current, since the system really at that point failed them. So the request is to allow Mr. Horn to pay the remaining $275, which is what should have been charged to him when the daughter tried to assist him on September 28th of 2014, and waive the penalties that incurred after that. That would allow the shop to be in compliance, and then I think their next renewal cycle's in like a year, so they would still be up for renewal whenever that is. This would get rid of the penalties added after that.
I make a motion that Mr. Horn pay the $275 and that we waive the penalties.
Do we have a second?
I'll second.
You've heard the motion and the second. Is there any other discussion? All in favor say aye.
Aye.
Motion carries.
Next on your iPads, and we are on page 146. This is a continuing education consideration. Dr. Robert Spalding has presented here on page 146 his information, and I'll do my best to do it justice. Unfortunately, he was unable to attend the meeting, is able to come back if the board would like him to. Basically, he provides continuing education online. Some shops have taken this courses. I think he's made it available for schools. They are offered by MediNail Learning Center. And I explained to him, of course, that we currently approve seminars for instructors only, and this is pretty specific to nail care or manicurists. He offers the training, again, to instructors as well. He is interested in being able to see if this can be approved somehow, and there's nothing that says that we couldn't approve it for instructors, obviously. So I told him it would be presented for the board to review and give him any ideas, feedback. I did also fill him in on the public chapter that is currently in the mix for all cosmetology professionals to see if that would be something that we could consider at that time. And currently, the breakdown of the classes is not the 16-hour structure that we need, but he said it definitely could be done that way.
But it's strictly just manicure?
It is. It is on not illnesses, things that can be detected,
stuff, yeah.
the sanitation. I think we could do an online demonstration ourselves, but I mean, biomechanics of the feet. I mean, I think you name it, and it's there probably for shops and anything that involves sanitation.
I think this is a good area
It's
to
a
open
very
up
good-
the manicurist in. I think this is a real good course. I mean, it's but 16 hours. Can they teach once the instructors take this course, and we recognize it as a course, as board approved? Would they be teaching like introduction to wound healing?
Would our instructors? Probably not. I think, yeah.
So it's kind of a moot point until we have advanced or
Right. But I think it would be good for
education.
like the nail teachers to have, to know, so they can answer questions that are thrown at them.
Yeah, I think
And
it's
that-
a big difference to know
Yeah.
the difference between sanitation and sterilization. Huge.
This touches on
Everything.
even really the medical side of things as far as
We took our
the
students to
disorders
a-
and all those things. It sounds like it really is good, and he does focus and do a lot with the medical.
If he would just get like the 16 hours that we required, I think that would be great.
And we're saying this would be equivalent to the standard CEUs that we offer for
We
instructors.
could. There'd be no reason why not.
There may be one small one.
Okay.
The rule requires that the entirety of the course be about teaching methodology. That's, if we can figure out a way to make this about teaching methodology on how to teach these, that'd be great.
That's true. But it might be, I mean, he's not asking for approval today, is he? Or is he?
I told him that I didn't think that we'd have enough information with him not being here for me to answer clearly, because we've spoken on the phone once. I've looked at it. The topic is definitely interesting. It definitely impacts all our shops. It's not that it's not something we don't need or couldn't benefit from. I just don't know of our instructors, if they took this, would it just be the manicure instructors? Because that isn't a huge number, but it could be limited to.
And on the
But even there.
cosmetology and barber side,
Teach the
we
nails.
both teach the
Oh,
nails,
yeah, it
so
has to be
Yeah.
open, right.
Has to be both,
right.
so.
So it would have to be.
Well, what
open
my
to
thought
all.
was, when I attended the planning session for the UT school, you know, the continuing education, you know, not everything, they sort of had to tweak things to make it be teaching methodology.
I think that'd be great.
You know what I'm saying? Because you,
They demo a lot there.
yeah.
Which is
We could give
sorta-
him an opportunity to tweak his program
Right,
to
just-
meet that criteria
That's right.
of board approval.
You sat through CEU last year. What do you think?
I sat through one of 2 days,
Yeah.
and that was enough for me.
Welcome to our world.
Gosh, I didn't say that out loud. I think this is terribly interesting. I think this is terribly relevant. I would love to see him come back under the the current instructor module. That's not the right word, but the 2-day.
A layout
And
for
I
the
think-
licensees.
To Mr. Ron's point, I think a lot of instructors, not just manicuring instructors, would be interested in attending this and would really enjoy it. I'll volunteer to go too.
But if it's so specific to manicuring, that's your entire 16 hours for 2 years.
That's what we do now. We take one class for 16 hours for 2 years.
No, it doesn't cover.
Not just a
For
particular
continuing
thing.
ed, they offer,
Yeah, they have different things set up.
right.
Well, I mean, I think there might need to be thought around, you probably don't need to attend this class multiple times. But I think it could offer some great variety in terms of what is.
It's online.
It is all online.
Well, I mean, a lot of people are going to opt out and just do it so they don't have to go anywhere.
It's true.
But if it's good, it's,
But it's very specific. So
it
you're
gives some
leaving out a
depth
whole
and
lot of
some-
other things.
Yeah.
Well, and I would tell you the one I attended was so broad, it was just on the opposite side. I mean, I don't know what the folks who attended the session I should not, it was.
Well, in the course of a career of an instructor, I think having some depth in each area is really important. I mean, it's to go for 2 days and just hit on the topic of, just the cream at the top, but it's still that depth of learning. And also this expands it to another mindset that our licensees would want to work for a podiatrist or a dermatologist, and this is the right kind of preparation for a teacher to now, an instructor to get into the mindset, this is an area we're going into.
I can see it would be perfect for an instructor of the manicure instructors. It'd be perfect.
But we have to get certified 16 hours every year through NACAS. And so, like, even online, we take some online on the years that we don't have to do it for the state. As a school owner, you have to.
Just to be
Or
informed.
instructor, you have to get.
And this is good to know,
Yeah.
just looking toward the future, if all the licensees require
Absolutely.
continuing education, this is just good to know.
Would anybody be opposed to having him come down here and talk to us and maybe give us some ideas about how he would present these things and help you decide? I don't want to hold him off if we need to have a vote, but if that helps somebody.
No, but I think this sets precedence for other people coming and having a 2-day very specialty agenda. Question for you, when you're attending the 16 hours every 2 years, do they track to make sure you're not just attending the same courses every year?
You don't stop anyone from attending the same ones, as a matter of fact, because it gets costly if they have to travel somewhere else. So many, if not most,
For the
of our
same one
instructors
over and
go to
over
the
and
same
over
one.
again.
And it's for the convenience, too. And we're seeing more and more going online, offering CEUs.
I think at the tech schools, there is some interest in having variety in those tech school instructor programs.
You have to take your test at the end of them online. And here we don't.
I've attended.
I'm sorry.
Go ahead. Go ahead.
Amy, like at UT, they'll run the same program 2 years in a row, and then they'll change up their curriculum.
Exactly.
And the assumption is that if they're doing that, right, that every 2 years they're getting in front of a new audience, and it is dramatically different, and so it's not
Right.
just the same thing over and over again.
Right.
I would hope that if we are starting to approve programs like these, that would be the qualification as well, that they can't just, run the same canned program indefinitely.
UT one is so informative.
This
it's
would be
really a good
perfect
one.
if it
It would
was
fit in there.
a part of a broader program. If it was 4 hours included into 2 days worth of
Right.
that would be perfect.
Right.
But
I mean, I'm sure every continuing ed seminar would love to have him as a part of their.
And I mentioned that to him. I think in the letter we can decide what we send him or if we ask him to come back. But I have told him to look online at the approved sessions we have and reach them directly if they want and can fit in a specialist of this level. I think with all the things in the complaint committee that we've discussed with our shops and salons and various complaints, it would greatly benefit business owners, students, schools.
So does he have brick and mortar anywhere, or is it strictly online?
Online. It's all online.
Okay, so he may
Yes.
not have that program prepared to present but I'm sure he could.
I'd like to see him come before us so we can
Talk to
actually,
him more.
you know, he can sell us or not.
And we're also, we just want to see how he's going to incorporate it in.
Well, and for precedence to say if you're going to be teaching a very narrow scope rather than what we've done in the past, what does that program look like for 2 days? And how, you're right, is it a teaching methodology in addition to?
I've attended classes, Kelly alluded to, where they did have breakout rooms or modules, as you mentioned, and if your particular module was, say, teaching to a dyslexic student, for instance, so it'd be specialized into that. There may be a component, how do you write a good quality test that's fair? That might be a different module. So in those areas, that's kind of getting into the methodology. But I've also been in those classes where they would do a demonstration of just a basic haircut. And this is how we think you should do a demonstration. That's teaching methodology as well. So
Topics are endless.
it is. It can go as broad as anybody can
Yeah,
imagine.
but if one of the university seminars, if they came before us and they gave us this outline that's going to be totally about manicuring, pedicuring, I don't think we would be jumping up and down to accept it. That's all you're doing? I mean, you're not going to,
Not for a continuing education for an educator.
yeah,
But that's what this is
that's what
for.
this is.
Yeah, no,
And it's more user-friendly because it's online. I mean, it's great.
Roxana, how do we deal
Beginning
with
of
that requirement then, because we have to attend versus online?
Well, you know, the online systems have come a long way. You would get a password and code and have to log in, and it tracks you. So
We wouldn't have
you wouldn't have a physical place to go.
a rule
Right.
issue with that.
No, I don't.
Okay, good.
Attendance can be electronically.
Yeah.
They'd have to prove to us how that logging mechanism, and we test it, kind of like we did with that barber school that for a while we thought could work out. These things are almost in every profession, so that's what we'd have to do. And right now, he doesn't have it chopped to the 16 hours. It's a week long, but he could. So I have that, you know, we're talking about the teaching methodology would have to be encompassed somewhere in the curriculum. It would have to be 16 hours, and I'd already discussed that with him, and that the board would like him to appear in person to answer any questions before further consideration, right?
No, and it might be that in the future, well, in the immediate future, an instructor could go to his, of course, granted, we approve things like this, go and take this online course for 6 hours, take, you know, what you mentioned, take a course of how to teach
Different modules,
dyslexics
different times.
on this online site, you know, as long as it added up to 16 hours.
Right?
Ooh. And then you got to get her certificate. I don't know. That just sounds really complicated to me.
But I'm just talking about looking toward the future. Everything's probably going to move toward this
I would
online.
agree with you, Kelly. I can see that.
Especially when
So much money for the people going.
everyone who's graduating in 2016 and in 2018, we better be prepared.
I mean, as an employer, if someone came to me and said that they had this certification from a program like this, I think that makes a very interesting resume to have a variety of certifications at this 16-hour program or another 16-hour program. I mean, you'd hire, if someone came to you and said, I want to be an instructor, I'm a manicurist, and I've taken this certification, that I would think would be a really valuable little feather.
Our nurses take most of their courses online, and we have certification, and we apply it and make it available to our insurance companies because they require those things, and they're recognized everywhere.
I'm not opposed to
So-
online at all. That's one of the best courses I ever took was through the University of Phoenix and online, and it was awesome. Very organized, and you really, really learned. And that's not my issue. This is just so specific for the 16 hours that you get every 2 years. That's
For instructors, no, yeah.
Right, that was my issue.
Okay, so we're going to send him a letter?
Yes,
Okay.
ask him to appear, that sounds good. Next on your iPads is a presentation regarding the Center for Cosmetology Education. The first thing, and I'll give you all plenty of time to review, is a letter from Ms. Nancy Ryle. Basically, the Center for Cosmetology Education, which is located in Memphis, had closed for due to the state tax authority for a total of 1 week back in December 2015. That was the last board meeting we had, if the board recalls, and where we presented this information. And so after they were allowed to open back up, business went on as usual for the school. Since then, and for various reasons, they have officially closed as of January 31st of 2016. The owner of the school is Nancy Ryle. She has provided an email with a quick recap of the events. She's asking the board to consider giving her 45 days to attempt to collect outstanding student obligations for those that have taken hours but still owe one or both of them, meaning either Ms. Ryle or Ms. Nikki Sparks. And that way they can collect on some of the money that's owed to them. Both Ms. Ryle and Ms. Sparks have discussed with the board office, with me, different plans on how to approach the students and try to assist them. None of those documents, however, ended up being complete. None of the information they were pursuing ever finally fully materialized. The Federal Aid Office has also been in touch with the board and shown some concerns and wanted to assist students that are stuck with having used up federal aid, missing hours now, and how to best handle that. Their concerns, as well as ours, and I'm sure the board's again, is the students' interest in them completing their hours. As of the last conversation with Ms. Riles, the school is now closed. 12 students were still unable to complete all of their hours. I believe on her email, if she doesn't here, she's got some ideas and recommendations for the students as far as a colleague that has a school in one of our neighboring states, and they could take in Alabama, and so no, that's where her husband is. It's one of the
I think it's Arkansas.
Thank you. I knew it was in Arkansas, so they could attend his school at no charge. They were hoping to work out an agreement with another school in the Memphis area, but as you all know, it's possibly even better to let the students pick where they need to go, someplace that's convenient. I know several of the schools have been concerned about them and I think would be able to work with the students. The question here is the board comfortable giving the 45-day extension? That would mean that the office would not be releasing hours until after that time if money is owed. Otherwise, Nancy will be doing transfer release documents for anyone that did no money. So that should have already taken place. They've been having conversations with students, letting them know their options. The issue is many students at least have contacted the office and said, we're not getting a call back. They're not, following up. And that's because they, of course, are in a sense of urgency and not to blame them at all. And you've got the other parties who have made the decision to close. So it's probably not working as fast as the students would like.
My question would be, legally, that would be a private party transaction on money? I mean, can we say we're withholding your hours because you haven't paid your money? Can we do that?
Well, for schools now, what we have done is respected the business entity, if you will, and given schools the opportunity to figure these things out and collect, because the schools are the ones that release their hours. What we've done in some situations where a school was revoked or closed and the students' hands are tied, the board has given me the authority to release those hours because the students have nowhere else to go. So this was the case when we presented it in December. The board said, okay, the school's closed for tax reasons. We don't even know if that'll ever be resolved. So yes, you can release all hours because no one's there to give us information. But within the week, as I started collecting information, it was clear that they resolved it, paid it, moved on, and were open. So we released no hours. I mean, we started the process and it stayed there because they were an open school and we respected and gave them the chance to get back on track.
They just haven't been able to recover since the closure.
Correct.
And the
I think
exposure.
it's a lot of issues. The owner has, and she states, health issues with her husband. She's been traveling a lot. The school hasn't been able, therefore, to get her first attention. The tax issue that came up has been resolved. The school is, and Ms. Happenfield can attest, a beautiful school. It's had renovation. It's large, which therefore implies a lot of additional bills. That I believe their current student enrollment assisted with, and the bad publicity really took a hit on them. So possibly a combination of everything. Look, Sunday, I did receive a complaint from a student already on the school with the whole story. It may jive with this story. It might be completely different. We're going to start getting the students that are just wanting the hours flat out. So it's a matter of, is the board okay giving them 45 days to try to collect some of this money?
Just accepting their hours to continue and finish up. Who is accepting all the others? Any other school will?
I pretty much I would. I know directly one school, Studio 75, when we had an issue during that tax week, was thrilled to take them at very reduced rates because they're a newer school. They're not accredited yet. You heard Dr. Joyner today. They want to get established. They think that this is sad for the students. So, and just like that, we would probably have others that would be more than happy. This other school that a friend of hers owns, I think it's only 100+ miles, if I remember the conversation.
Oh, you cross the bridge, you're in Arkansas.
So
Not very many people
there'd be
realize
no
that,
fee, but I don't know that kind of driving is feasible to all of the students. Now, we've got 12 in the middle of this, so those 12 would have to still complete hours, but we have a lot of students who finish their hours and haven't been released because they owe money from back, and those are the students that'll very likely be reaching out quickly.
I think if we release hours, we definitely should stipulate this in no way releases them from payment to, of monies that they owe
But we
the
never
school.
touch on the money. That is not our jurisdiction. We've never, just like any other business, if these hours are released as a business, you can go to collections, you can hire, that's
Okay.
what we are, but their point is, and rightfully so, what the student wants is their hours, and so that's how they have something to hold on to get the money.
In years past, on the barber school side, there was a provision in the law that stipulated that all students had to be paid in full or arrangements made prior to release of their hours. So it wasn't just a business decision and I have to go to collect from you. It actually made it an act of law that we held their hours, and they really didn't have any argument about it. They couldn't say anything about it until they were completely paid off or arrangements were made. Now, that's going away, I believe. That's not going to be in the
And it was
iteration.
never in the cosmetology statute, which is
Exactly.
what this school is. But just like many other things, for the office to function, we respected both types of schools and tried to, as long as the school was in good standing and working with them, respect and make sure they paid the school. So
That, again, today, those things are contractual between the students and the school, and you still have, the school still has the legal system to
we do.
secure payment, but the student also has boards like us, and they also have legal arms to get out of that. If the students have attended the school, I don't have any problem with the student having to pay for the tuition, obviously, but
And other schools that have closed, how quickly do we release the hours, or do we?
In the past, way back, there have been schools that have closed and we've not released hours. I mean, before I got here, I mean, they just, if they just had to make it right, they had to find a way for the school or instructor to vouch for the hours. So a lot of students were impacted back then because they weren't released. Between technology and the board being, very proactive to figure out how can we assist students, we've had revoked schools where, we've looked at the hours and they were there and the school's revoked. We've released those. And it's been clear that if, the school comes back and asks you to pay, that's that contractual agreement between you and the school. We are just letting you continue school somewhere else.
That 45 days benefit the students?
It makes me a little bit nervous. I guess allowing us, the board, to be used as sort of a motivation for the students to pay their debt. It makes me a little nervous. I don't know. I guess just with it right out there in black and white. I mean,
I believe as a board reviewing these things of schools and students, I think it is our intent that if a student enrolls in a school, is that we sort of have a guardianship over those, whatever happens, there's a guardianship over those hours, and we need to be, I think, responsible that the students complete those hours and take their exams.
We're talking about the ones that have completed hours but haven't paid their bill yet.
Well, I don't think that's our business.
That's
I don't
what
think
I
that's
just
board
said.
business.
Right.
Yeah.
Laura, let me ask you a question. If Kelly's a student and I'm a school owner, she has a contract with me to enroll in that enrollment agreement. If she stipulates in that enrollment agreement that I can hold her hours as a collateral type situation, then does the board have any ability or role to release that? We're not in that contract.
Copy of the school's contract? That's a great point.
Schools.
That was one of the
My
most.
point would be, if the contract doesn't stipulate that, then who owns those hours? Who controls the hours? Versus if it does say that.
That was one of the most organized
that's-
schools I ever inspected. Oh my God, they had everything like as a role model, So
And should the board delve into that?
So if there's a contract between a student and a school stipulating each other's responsibilities, the board isn't a party to the contract, so we're not bound by or held by. The board is the board. They're not part of that contract. I think what Roxanne is saying is basically before the problem with the Lyle school, the board had never released the hours because it was sort of the way after there was kind of an issue, we determined that the board does have the authority to step in and release those hours. The board does not have the authority to waive any money that anyone owes anyone else. We can't release anyone from their contractual duties between private parties, but if the board determines that they want to release the hours on their own, the board does have the authority to do that.
When that school certifies those hours to the board, then they've said they're completed and done, irregardless of any monies owed and things like that, so.
Yeah. So it would be different if we didn't get any hours until the very end, but those schools are giving the board office hours every single month. So it's not as if we are already playing a role in between the time they start school and when they
So in the past,
graduate.
when we ruled on Lyles, just to try to be consistent, we said an immediate release of those hours.
They filled out an affidavit, and on the affidavit, they let us know if they attended a different, another school besides this one. And I think there's a place that touches on this. This is only about the hours. It has nothing to do with the financial piece.
We verified the hours the best we could. And
Right, we verified the hours the best we could and released anything that matched.
Yeah, but we kind of, the school was in the wrong, I guess, in that situation. In this situation, it's not like any wrongdoing has occurred outside of
That
the
you have
students
been
not
made
paying
aware
their
of.
tuition.
There's not been any wrongdoing to what this
Well, from
board
the
has
school.
made aware of.
Yeah.
Most businesses that fail, there was something that went wrong, and we've just not been made aware of it.
so the question, I guess, for us then remains, do we want to release these hours or take all these hours for these 12 students? Or is it just the 12 or is it more?
The 12 have hours pending, so they're unfortunately going to need to go somewhere else to continue.
finish.
Or it's my understanding that Ms. Sparks or Ms. Ryle will give them the transfer because they have hours pending. They're hoping, I'm sure, that they go to the school that they've kind of worked out a deal with. And I foresee some of those 12 coming to us and saying, I'm not happy with the recommendation. I'm not getting a call back. Can you give us the release? So I think we probably will hear from them. We're also most definitely going to hear from the ones that have been waiting to make payments on, putting it off, or had moved or whatever, and now all of a sudden they're gonna hear through the grapevine quickly, the school's closed. So now what? Those we're gonna hear from, because in that week that they were closed, those were actually more than half of the students that called. You know, yes, they said I owed, but I didn't owe, and now I want my hours.
Did they send in withdrawal forms at the completion of their hours?
So as of yet, I haven't gotten any last minute withdrawals. 7 have finished in the last month at the school. So those we should be getting. They are waiting for the students to decide, do they want the withdrawal form because they're going to another school and gonna need it, or are they still paying on hours that they may owe from the last month or 2 months? If that makes sense.
Oh, well, I know on the withdrawal forms that I do, it, at the bottom, it has release hours or do not
Or do
release
not.
hours. So if they've already turned the hours in and done a withdrawal form and put release the hours, then
Those are irrelevant. Yeah, that, we wouldn't even have that conversation. Those would be released. They are not going to fill out a form on those students that owe them money.
oh, okay, I see what you're saying.
So they're wanting us to do the same thing, wait 45 days for them to work out a payment. I've been told they were going to negotiate the fee, but again, a lot of different things have been said, and with us not knowing what is owed, we're not going to get in the middle of did they discount the fee or not. That would be a nightmare. But I believe that that was their hope, to be able to.
Coach, does she have any,
something.
well, I guess there's no time set to begin with. She's just asking for time.
Well, in the past, if a school has just closed, we haven't done anything.
We've left it to them to do the, whatever their contract said.
That's why I said, with it being in black and white, can you withhold their hours until they pay us? That makes me a little uncomfortable.
If it says that.
Well, I mean, she
doesn't.
She says it, pretty much.
They've struggled since I've been on this board. There's been a lot of, I think I've been over there 6 times, have I? Yeah, at least. I would make a recommendation that these students, that we would release their hours. It's been I mean, it's something I really can't discuss, but I think it would be irresponsible for us to take our eye off the ball that these are students who have enrolled, have made some commitment in gaining hours and paying some fees, and they want to be cosmetologists. I mean, I just think we should push that along and assist them if we can, because that school has had a struggle since I've been on this board.
Are they asking for, are they asking the board to grant this 45 days?
They're asking the board to not release any hours for 45 days unless they themselves have submitted the transfer form on which they would be
Okay,
releasing.
so if we vote against that, then they've got to release hours.
That doesn't prevent her from still trying to collect the tuition that
Absolutely
she's
does
owed.
not.
She can
Absolutely.
still do that, just not without
Right.
us blackmailing them with their hours.
It takes away those
Exactly.
hours, right, as a tool.
And that school that merged with that school was a problem. So it's just,
I think
the
they do have-
students kind of,
So this would set the precedence for any school that we license. If they were to close or merge, students could come to us or come to the board and say, I want my hours released, even if I haven't made my payments.
Right.
No,
And
these
do
are
you-
these are students that have earned all of their hours. They've completed their hours. We're not talking about the 12 remaining, correct?
The 12, it would surprise me if they don't come and ask us to quickly give them a transfer. But right now, we're talking about if anyone prior to that still owes
I
money,
could see
which is
releasing
a
the
lot.
12 so they could go on to another school and get started and finish up.
but even, I think we'll hear from parents, they
But-
put
Oh,
their.
we have.
Oh,
We
my
have.
God, I'm surprised you
We
know,
have.
because we heard about them about
we
those
have.
kids, but.
If the board recalls, when they merged, one of the issues that several parents had is that the students had part of the, at least with Plaza, part of the contract and original fee included a kit most of these students that are still there right now, coming from parents and students, so say they've never gotten their kit. They've yet to work on the $300 or so kit that they have already paid for.
And I live and work within a half a mile of both these schools, so I mean, I hear it, and it's in the Memphis News. It's it's been I would align it with what happened at Lyles. It was just a bad situation that got worse. The school is now closed, and I think the students have had a rough go of it. I'm sad for that, but I don't think when your child comes to you and says, I want to go to beauty school, and they want to go with all their friends, that you assist them in finding a school that is going to stay open all the way to the end. I just think it's a bum deal for the community and the profession. And I think those kids, we should assist them in going forward.
Yeah, but
But
right
they
now,
should also have due diligence and do good research
Oh, yeah.
and go to good schools. And you asked a question, Amy, about how I felt about it. I want to step back here and just give my opinion on this as a school owner, okay? As a school owner, my relationship with the student is what we have in writing. We have enrollment agreements that spell out everything that we want to spell out. Students have the ability to negotiate that. We additionally have promissory notes that the students sign along with co-signers that make them financially responsible. In those agreements and notes, falling back to the old BARBER rules, we actually stipulate in there that the school does hold those hours. The school does hold their kits, or anything that they owe to the school is still bound to the school. That doesn't have to be released. As a school owner, I would be really worried about the board stepping in and saying, hey, I'm going to subterfuge your written contracts there and just
You're an open
release this
school.
automatically. I'm not saying that we should grant something additionally that's not in their agreements, 45-day extension, but I'm really seeing the devil's advocate on this. As a school owner and as a board member, my true first consideration is for the welfare of the student. That's where I run my business. As a school, even if you owed me money, I probably would work out some arrangement with you. If they're simply asking for time to make those arrangements, that's fine. But I don't think that I should be able to come back later if you didn't agree for me to hold your hours. I don't think I should be able to come back later and, as you said, use the board as the hammer to hold that over your head to hold your hours. If your contract said they could be released, then I think that's what we should consider or not. On this particular issue, I'm going to go ahead and say this as a school owner. I'm probably going to abstain from this vote because I don't want to have any sense of impropriety on that.
I agree with you on that.
I'm just trying to decide what the best decision is so that we're not stepping into something that's out of our, realm. They have contracts. Well, can't they just go by that and we can just say,
Correct.
we're not going to vote on any of this? I mean, or can we say that? We're not going to vote on it? Or we deny all these requests because go by your contract or whatever?
We definitely can. I mean, we can say we're not going to release any hours. In the past, like I said, we didn't. We can, again, Lyles takes the precedence. That's that first time we were faced with so many students that needed our help.
It's not the
We
same
took their
in that
license.
we
It is not.
revoked.
You're absolutely.
What about if we, okay, we I think several of us feel uncomfortable with her being able to say, well, the board said they're not going to release your hours until you pay me. So what if we don't agree to that, but then allow the students, like if a student contacts the office requesting their hours, I mean, maybe all the students won't until there's no way to foretell.
I don't think the board has to say that. I think the board can say that this is outside of the scope. This is between the student and the school and
That's what I'm
the
thinking.
contract. And
Right, but if a student requests their hours, has that happened?
Oh, the minute they were closed for that week.
Yeah.
I had 15 students waiting for the withdrawals. I mean, they and their parents were ready for them.
That has
ready
to
move
come
on.
from the schools.
And don't
It
they have,
normally comes from the schools, yes, but in December, we said that if the school really had been shut down and couldn't do anything, we would release them. Now the school is saying, we are going to be available, because I've asked both. I've said, when they call you and email you, you all have to respond, because what gets the second and third person and the friends and everybody involved is when they don't hear back.
Is the school open now?
No, it's not open. Their official day was that Saturday, the 31st.
But they're there to give withdrawal notices.
There is an email address that we have, and then Ms. Riles, I believe, has released her personal cell phone number so that students know to reach her. Those students that finished 2 years ago and didn't pay and are still on hold may not have an easy way, so, you know, because they may not, but we can give them that. We can release that email.
Can I ask you this a different way? Is their license still valid? Are they-
Until, yes, August 30th, absolutely, because
So
cosmetology
they are
schools.
licensed, and if someone wanted to walk in and enroll today, they could do so.
Well, no, because they've given us written notice that they're closed, but they
Oh,
still have an active.
So they've notified us they're closed?
Yes,
Okay.
yes. This email is her notification that as of Saturday, the 31st, I think it was, they are officially closed, or Saturday, the 30th.
if I'm a student there, can I go there now and say I want my hours released?
No, you would need to call or email one or the two individuals. The administrator is Nikki Sparks, or the owner, Miss Nancy Rowell, and say, I want my hours released. Then the conversation between them could go,
That's
well, you owe me
negotiation.
300. No, I don't. Here's my, and that's what we've been encouraging every day for the last month or so, as they've not been happy. We've, but it, you know, just completely gotten outside, let them negotiate and figure it out. Now the thing is going to be that we're going to have all of them reaching us, and we could again do the same thing and say you need to contact this email and this phone number. Now the Board of Education and the federal aid, two different individuals with federal aid, have reached me. We've had conversations. They're hoping to be able to, so I've got their names and information to give to students. They're hoping to be able to help students, and I don't know what that help means, whether it's forgive some of the money or not. I can't speak for them, but they have gotten a lot of calls from the students and parents about, okay, well, I took out, this is the loan, but now I'm stuck. I'm in the middle of this. So they are very concerned on how we handle it as well, because they
Right.
see a lot of students are going to be stuck in this.
Have you seen the contract between the student, in other words, if I was a school owner and you enrolled in my school and it's in our contract that I withhold your hours until payment, then if they've signed it and I've signed it, does that not give them the right to withhold the hours until they've met that payment?
Well, we approved the merger of the schools in June,
Right.
May
We
or
looked at their
June. So
records.
we've looked at that contract. It's a pretty standard contract.
Yeah.
It doesn't say, I will hold your hours hostage until you pay me. It doesn't say it that way, but
I'm also a
it
little.
says you owe money, and your money has to, you know, the hours have to be paid.
Also makes me think, why? Something must be fishy, or you wouldn't be asking for the extra 45 days. Like, why do you need some ammunition to collect payment that you've agreed on?
Roxana, as we discussed, I have to excuse.
Let me see if I can answer this real quick. I have a feeling it's because they know that we have released hours for other schools. And when it was closed for that tax thing, we'd made the decision that if the school stays closed and there's no one to be reached,
Well, and that's
we've
the
got to help
kicker.
students.
So if I'm a parent or I'm a student and I've called this school and no one is answering my phone calls and no one is getting in touch with me, I get that. That would be where I would feel okay stepping in and saying, if you can't come to a resolution and there's no negotiation, then what else can we do? But you're saying that now there are very clear people who have provided information, and do we give them, I mean, obviously it can't go on forever, but if their point was, I can't get a hold of anybody and I want to know what I can do next, I understand. But it sounds like they're open to you can contact us now.
Yes, we should. And I've said, you know, we've got to be able to reach you at all times, or somebody, because that's what's going to happen. Parents and students will say, I've left 3 messages and no one's reaching me.
I would think on that, we'd have to advocate for the students like we have in the past.
Right, correct. And how it will go, hopefully this time it will be different and they'll be able to be reached and answer quickly. And we may have to readdress it in March. I mean, that is an option if the board,
I'm just concerned if we just release these hours and get between the students and the schools and side with one or the other, we are going to have a lot of very angry school owners.
Oh, but hopefully we won't have this situation.
Bill.
Well, you're gonna have it every time the
Schools
student doesn't
closing.
wanna finish school and drops out, and then,
Yes.
They don't want their money back.
and then they don't wanna finish paying what they've owed according to their contracts. That does happen.
So that's what you run into.
Yeah.
Because anything is usually 50%, if they're there 50% of the time, they owe the whole amount. If they quit at 51%, they don't want to pay it.
And that's the key, that
That's
how
it.
far they are in advance. That puts them all in a tough situation. I bet you all 12 of these are way past the 50%. Because the thought when mid-January they said, it's not gonna work, we're gonna close, was that many, if not all, would finish. And of the 17 original number they gave me, we're down to 12 still missing. That means, you know, they either didn't offer enough flexibility in hours, whatever it could be, that they didn't get done. But some of these students are lingering as far back as when Plaza was still licensed, so that goes to May.
Okay, so the only thing we have to make a decision on now is whether we're going to grant her, we're going to withhold licenses for 45 days. That's what we have to decide.
Well, not licenses, hours.
I
is
mean,
if we're
I'm
going
sorry,
to completely,
hours.
yes, pull away and not release any. That's what she's asking. And I think that's, again, you know, situation going on between Ms. Sparks and Ms. Ryle on who's releasing what hours, who has how much money owed to each of them. And we definitely don't want to get in the middle of that thing at all, because
Looking at the history of it, then the board typically would not have in the past released those hours under these requests. We would have depended on the student and the school to come to some kind of arrangements, and if they had to get into legalities and go to litigation, then they'd have to do that. If the student prevailed, then we would certainly have released the hours. I know we don't want to create an additional hardship on the students, but we don't want to start a slippery slope here, and we don't want to create a hardship on schools as well. We just want them to do what they said they were going to do.
So just like with Stain, I would just say, you know, let them work it out. If they get their money paid off, give them their hours. I mean, that's their bond between there's a business. It's just like running any other business.
So what we would be saying is, we're
Telling
denying
them.
this request.
Yeah.
Right?
Yeah, I think we just
I think so.
elect not.
We deny the request, but we
Yes.
also just don't release the hours.
Right.
No,
Not just, here's your hours, go to it.
I
which
think
in
it's fine.
essence is approving the request, because what she doesn't want us is to release
No, I
the
don't
hours.
want to approve, I don't want to, I don't know.
We have some
I don't think we
thoughts
have to
from
approve
legal on
anything.
this.
Now, let me also just remind you that if the students can find them and work out an agreement, that's great, but part of the student's concern, of course, is now what school do I go to? And they've tried to work out an arrangement, so they did try to come up with a plan in writing, because my hope was to present a teach-out, like what we're asking for the new schools. And the school that they confronted was actually upset that we would have mentioned that there was a teach-out. So we had to backtrack and say the school's not at all associated with and is not going to do this. Just, you know, because they are concerned from having talked to federal aid, Department of Education, just they don't want to be directly connected with fixing this problem, which means that they know it could open up a big can of worms. I think the schools in the area would be more than willing to talk to the students. What's going to happen is, because a lot of these students are lingering from Plaza, they are actually frustrated and upset. So even though we may not give a direct answer to the 45 days, anything we decide we'll have to have pretty clear, because the calls are waiting for after today for every student to know where they stand and make sure that it's, we guide them back to their contract or whatever we do, that it's pretty set.
For contracts. And these 12 students that are waiting to be transferred that have not got their license, I feel like they should be able to go ahead and be transferred. That she should release their hours to be transferred, and let them pay her off. And when they get her paid off, then she'll send their hours on over to wherever they go to.
Per their contract.
Per their contract, yeah.
Kind of a catch-22, guys.
No, it is.
A denial on
Such a
one approves
mess.
the
More
other.
than 50% of the school, then they technically owed them all the money except they didn't even have the opportunity to finish.
What's the,
Complicated.
what's the recommendation?
I think Friday, I said, the drama and the varying stories that have come from both sides have been incredible, not to even mention the parents and students. I mean, I feel for the parents and the students. I get the business side as well, and I think the board office wants to be consistent and fair because it could open, let's hope more schools don't go down that path, but it could open a can of worms. But historically, if a school's closed, it really was, we're so sorry. I mean, that's what the students got. I think we are viewing things differently, which is good. We hate to see the student being that victim. That's what's changed, I think. And
Afraid you're going to see more and more schools with all these
No.
new the post-secondary and stuff. It's going to even get, it's harder for schools to survive now with all this new stuff. Is it not, Ron? It's crazy.
With, how can we craft this in a way that splits the baby, that doesn't harm one and take sides over the other?
Well, the only thing I see in the wrong is clearly some pretty bad things had to have happened for this school to find itself in the position that it's in. So that's one count for there's something in the wrong. The student, maybe this student's in the wrong because they haven't paid their full tuition, but it's kind of like, why should I pay my full tuition? I'm not going to get my full hours.
Maybe they can sit down and talk with them and negotiate the price.
Well, she's
They
listed
need
a discounted.
right,
Yeah,
that's
they
the
need
plan.
to, they need to work that out and then see where they're at with that. It's the way I look at it.
Yeah, I don't think we should even touch that.
There.
So what happens if we approve this and she has this request for extended 45 days to allow collection, even though she do not think much money, if any, will be collected? It would give her some time to tie up loose ends, and we don't know what those loose ends are.
Oh.
After the 45 days, then what happens?
Then you release.
So if this was approved, what happens after the 45 days?
I believe then their thought is that we would readdress it and possibly consider releasing those hours.
How about just releasing the hours after the 45 days? Point blank.
We meet again in March, so it could be even before then. We could make the decision to do nothing, because it sounds like that's the thoughts.
Yes.
Doing nothing as parents
Well,
and students call.
she can go about what she's planning on
And do it.
giving, trying to work out an agreement, but not being able to say, well, the board's not going to release your hours until.
Yeah, no, that's
but
exactly what
clearly-
I don't want to fall on our shoulders.
Right.
because-
And then clearly, for me reading this, what I hear is I'm not going to have the money in 45 days anyway. That's what I hear. So,
Well, and I think if you're a parent, you're saying, well, you closed. Why should I owe you? To Kelly's point, you've assured me, I've contracted that you're going to provide 1,500 hours of education, and if you're certain way along in the program, I owe you all of that, even though you're not going to fulfill your end of the bargain, which is a problem.
Well, and she's saying she's going to reduce the price, and
I think they need to try to work it out and see before we ever get involved in it.
I think they can take that to Judge Judy.
Yeah.
yes,
Yeah.
I think so
Judge
too.
Judy got the
Somewhere
answer.
else.
I just don't think we need to get
Should
involved
do
in that.
nothing.
I just don't want to open it up where you've got students starting schools or maybe go all the way up and get their 1,500 hours and they've not paid the school at all, but now they still get to go get their license. And see, that's not, if we start getting involved, then that's going to tear down our schools.
What I'm hearing, I think, is that the board, in its discretion, may be leaning towards not acting on this in one direction or the other, and have an eye towards, if this isn't resolved between them by the next meeting, it'll come up again, I'm sure.
We'll revisit it.
Revisit. Is my feeling
Yes.
close on that?
We're going
We're
to
saying
defer
good
for
luck
the
with that.
student contract.
Right.
I mean, we're going to defer for the contract that's in place
Right.
between the student and the school. I don't know if you can say we are glad that you've put together a reduced tuition payment plan, and
Out between themselves.
To keep that less is better.
Business and keep it.
Thank you,
Now,
Nina.
Business.
now what this is doing, members, is we're effectively dumping this in poor Roxana's lap over here. And I don't want to leave her without any arrows, without any defense.
But I think if we meet next month and there has been, you still have parents saying, I mean, it would be a big problem if the school's not taking the calls and they're not willing to work out an arrangement, right? Those two things would trigger the fact that we do need to get back involved.
Right.
But right now, I think we need to stay out of it.
Yeah.
Right.
You would be able to keep notice that, but the parents are saying they're not getting called back, they're not getting emails back, they're not getting, if that's the way that it's happening, then I feel like we need to step in and release the hours. But other than that, until next, I'd wait till
They've
next
provided
month.
contact information for her to give, right?
But if they're giving it and they're not replying back to them, then, maybe we need to look at it again.
At that point, our hand is forced and
I
Right.
feel like she was just trying to gather ammunition before she went before them with
the
her.
board's not gonna,
But,
she wanted to use
and make
us
it
as-
clear to her that she's got to return these calls, and if she's not, then we will be stepping in.
So we're leaning towards not granting this request, and at the same time, not severing the idea that we could release the hours.
That's how I interpret it. And I think it's going to be really important that the board office keep a list of the name of the student, find them on the hours report, have at least the last four of the social, know how many hours we're talking about, what it is that their need is. Not prepare an affidavit or get anything, because we may or may not ever need it. Hopefully we wouldn't. But it puts the student still and only the student at that uncomfortable place and in limbo, because they're having to wait. They have no choice but to wait. So they end up being the victim again, but it is one of those situations.
Not. Maybe, if they call, hopefully, they call her,
And
they
can
work
work it
out an
out.
agreement,
Yeah.
she signs the paper, and
Yeah.
they go on their way.
If they're doing their part, like they should do, and the school is doing.
I think Amy kind of nailed it when you said the student has paid quite a bit more, and per the agreement, after 50% doesn't get a refund. So they've gone more hours, but they haven't finished, so they haven't gotten the full product, but
I
they've
didn't say that.
paid
Kelly
more.
said that.
Oh,
She's
I'm
gonna
sorry,
have to
Kelly.
drop it
Yes,
down.
so they're stuck and angry,
That's the
obviously.
negotiation there.
That's when you need this kind of negotiation.
That's, yeah.
So,
And it should
maybe they
work.
sit down and the student says, I'm not comfortable paying you anything else. And she says, okay, well, here's your signed, whatever you
Get it
call
open.
it.
And she may come to that point just to get it all closed up and out. So
But she
can
says,
move-
even though I don't think they're going to give me any.
If it came to that in court, I believe a judge would say, what's inside these four corners? That's what you do, and that's the end of it
in the contract,
in the contract.
yeah.
Wasn't the first party to break the contract by
Yes.
not giving them a full education, though.
Exactly.
I just want to point that out. I don't know that that's relevant to this discussion, but it's not like the student is the only one that's breaking the contract here.
Right, right.
Well, and so thankfully, she's willing to negotiate the original contract.
And
So
so I'll
hopefully
make-
she'll do it.
So we're gonna make a motion.
The board make a statement too that we get involved with the releasing of hours if a school's license is revoked by our board, or if a school has closed and there's no contact in which hours can be released. I mean, because we shouldn't be in the business of choosing to
Yes.
release hours or not. But
No.
if there's a non-response and we have to get involved, we will. Or if we've chosen to close the school, then it's clearly in our wheelhouse to figure out plan next.
Right.
We're gonna make a motion to deny,
Second that.
how do you wanna word this, Ron? How can we word this?
The request.
Deny the request.
Deny the request.
Second that.
And that she is to make contact with all the students, or maintain the contact.
Or get out.
Can't we all just get along?
And then at the very bottom, put, good luck with that.
Okay. Is that a
My
motion?
circus, not my
It's a
motion.
motion.
Okay, we'll
I'll
need a second then.
Second
We have
it.
a second. All those in favor say aye.
Aye.
Opposed say no. And I abstain.
In 30 days, we will revisit this, I'm sure, with where we are in terms of,
I believe
Progress.
at that point, yeah, we may have those students that are gonna choose to file a complaint officially and have the board review and decide what to do. That would not surprise me.
you advise the students and the parents who are calling you to really be clear in documenting their contact with the school, so that if they were to come to us and say, look, I've called, I've come by, I've done this, and there's been no follow-up, that it is very clear that our involvement is needed to resolve this.
Okay.
Ran everybody off.
No, Ms. Sappenfield had to go to the plaza, so I knew she was leaving. I know she felt bad that we didn't finish, but, and we do still have quite a few.
But I'll go.
ran everybody off.
Yeah, we ran.
I'm focused.
They are all going.
I love it. Okay, good, because we can go on with, the next one's not that fun. So next on your iPads is a change of ownership. We are on page 156. This is 2 applications for change of ownership for a school have been received in the board office. Barber school license and a cosmetology school license for Pyramid Beauty School. The only document provided with the application and the fee was the application. The new owner appears to be Cleophas S. Bryant, who is related to the former owner of the school. Mr. Bryant has not contacted the board office with the required information and was not, had not informed that they were appearing before the board or wanting to be presented. This morning, they were here for a little bit, also with an attorney, spoke to Lauren, got some guidance as to what we were presenting and how we would be presenting it. I'll let Laura fill everyone in on what these 2 applications mean and kind of some guidance for what's next.
Pyramid School was revoked. Their license was revoked by decision of the board. The order was signed, and now that school is the subject of litigation in Chancery Court, I believe. Their owner of that school has retained counsel, and they're trying to overturn the consent order and the decision to revoke. Haven't had that hearing. That won't be for a while, but in the meantime, we received an application for the same school filed by a family member, and contacted the attorney for the original owner and asked if they were pulling their litigation, or if they were they have brought suit on us. We haven't brought suit on them, so they're kind of the ones moving forward. If they were choosing to pull that litigation and instead of trying to overturn the order, instead just apply for a new school license, and they said, no, we're not pulling the litigation and we're not pulling the school application. So we processed the application as normal. Legally, I couldn't recommend that the board approve an application like that because the school license requires facilities, and since if the license were to be approved for that specific facility, and then sometime in May when we have a hearing, if it is overturned, then now we have 2 effective licenses for 1 facility. So we did not know that they were going to come here today. We hadn't heard from them. I advised Roxana not to contact them because I thought they were represented by counsel, and so I had contacted the lawyer. Turns out the family member who's trying to open the school is being represented by a separate lawyer who I spoke with today and explained what my legal concerns were with advising the board that they should approve a license for the same facility. So I think that they are going to attempt to
Motion to deny.
I second that.
We have a motion and a second to deny. Any other discussion? All in favor say aye.
Aye.
Those opposed say no. Motion carries.
Okay, so next on your iPads, still with this school, we've got some issues with releasing of hours. At the previous meeting, I had requested some release of hours, and some of these were able to be processed. Basically, at the December 14th meeting, we had several names of students that had hours from Pyramid Beauty School that the hours did not match the reports that the school had submitted. We only approved those where the hours were either exact or close enough, but we had some with huge discrepancies. So before you are two individuals from that school. Mr. Gabriel Motley had a variance of 333 hours with that school, so I was unable to provide him with anything unless he could give me additional records. He had provided his affidavit, and several weeks later was thrilled to be able to find, which is on page 161, the actual attendance detail that the school did hand them out, I think once a month or so. And so if you look on, where it ends, page 164, left-hand corner, scheduled hours, total accrued. So it shows that he has stated in his affidavit that he had 533 hours. The total hours accrued say 512. And so I think that's close enough to his hours to show, because all that we had on our hours was 225. So that 512 is, at least based on this record, which I recognize, I've seen these reports from that school before, we could release, or we could go with his word on his affidavit for the 558 hours that he is stating.
$46-hour difference.
Right.
And all they had turned into the board was 200?
125. I'm waiting on several students that have given me very sad stories and aren't going to be able to find anything. Mr. Sims does put his in writing, and you all will read it in a minute. But yeah, I mean, so this is about as great as it's going to get. The fact that he found a report that has something, I think the 512 is a given, actual accrued hours. And if the board decided to give him exactly what he claims he had and attested to and looked for, at least he's pretty close there, because giving up on 333 hours was going to be tough.
He's got 31 hours or so in makeup hours. How is that calculated on this sheet? It's on page
The last one?
164 of the iPad.
Yeah, yeah.
I see the total 741, I see the 512, and then I see the excused absent hours.
228. Mhm.
On that line, there's also 31 and a half makeup hours. Would that explain some of the difference
That would probably be the difference
between his 512 and 540 something?
between his unexcused
558?
hours and you add that into it for the makeup hours to get the total 741.
That mean he needs to make that up, or he made it up, made the hours up in makeup hours?
Back a little bit farther and see if there's another one.
Now, he himself is only expecting 558 hours. He at no point said he had the 741 or
Oh,
close
no,
to
no,
it.
no, no,
Right,
I
right.
was just
I
trying
think
to
he
make
made
up the
That's
total.
gonna get him
made those
closer to
hours.
that.
Oh,
Yeah.
absolutely.
I think he made up those hours.
That's the only thing that it's showing.
Made up.
we're
That he
not
made
calling
up,
it.
Needs
yeah.
to make up.
And that would
He already
not,
made 'em up.
from speaking to him, he didn't put anything else in writing, but when he found this, he was ecstatic.
I bet he
Should be.
was.
And the difference was so minor, like I said, if the board is comfortable with his sworn affidavit that he had the 558, that is close enough, because it's not up until the last day he went, obviously. He found the only report he could find.
Right.
I'm comfortable with giving him the hours he's asking for because of the makeup hours.
We have a motion to approve.
I make a motion.
Second.
Motion and second to approve. Any discussion? All in favor say aye.
Aye.
Motion carries.
Next on your iPads is Dietrich Sims. He submitted an affidavit for 300 hours in natural hairstyling from 2010. The board we requested boxes from our storage facility, went through all of them to look at the school's hours for that period, and didn't see where Mr. Sims' name appeared on any of the reports. His explanation on this letter leaves a lot to be concerned about. And it is not the first time that these type of explanations have been given to the board office regarding how the owner tracked hours or submitted hours on the monthly reports and why the variances. So we have no hours at all for this individual, and I'll
Doesn't have a copy of an enrollment agreement or any kind of paperwork that we have?
He told me he could find nothing from the school. He's done the affidavit, obviously, but he has nothing in writing because when he signed and started, he didn't get a copy of his contract.
And he's saying that at 300 hours, he sits for the test if we approve this,
Right. He would fill out the application to test and move forward.
because he
if we
doesn't need
approved
any
it.
additional hours.
That's
So
correct.
he
That
would
is
just
the
move him
total-
to the test.
We have no way of showing that he was ever even enrolled in the school.
I'm concerned with why he's interested now after 5 years. Is
I'll
anybody
be
else?
honest with you, from that school, when the school closed for one reason or the other, we had at least 40, 45, I don't remember the number, of students. I've probably been contacted only by 7. And I lie, it's probably 9, because 7 of those were on Veterans Administration, the VA bill. So they were interested in going somewhere else, and then the VA representative, who also has been very concerned about the school for a long time, contacted us to kind of figure out what to do and how to help these folks. Why the others haven't reached out, I couldn't tell you. I do know that another school in the area has taken many of these students, had taken them without the transfer release form, so we did have to get involved and say, as far as we know, no one else has transferred, and then they did fill out that paperwork. So my gut is that the students then have the vast majority moved there. But from his story and others, they paid little bits at a time. That's the reason that we did a suspension period, just to try to help them get some of these things rectified.
I would like to make a motion based on the information or lack thereof of what we have, because, this should be a lesson to him. He needs to keep some paperwork and some records.
Bank statement, does
Yeah,
he have
something.
no bank statement?
So
that
I make a
would
motion
show
that
it?
we deny his request.
Second.
Could you ask him for records of payment, copies of checks?
You'd ask him.
I've asked them, I can say they've denied because, so if you come up with more,
But
then
there's no
that's a different
proof.
issue, but yeah.
Prove it
Something,
somehow.
Somebody's got to prove
something.
There's nothing.
We have a motion and a second to deny. All those in favor say aye.
Aye.
Opposed say no. Motion carries.
I've got Ms. Coppinger making the motion. Who was the second? Oh,
Ms.
thank you.
Kitzler.
Okay, all right. Next, we have permission here, or request permission from release of hours also. This is from Lyle School of Cosmetology. The board had previously authorized me to release hours through July 30th of 2015 only, and fortunately, we were just about done. So now we have a request at this time for Thuy and Nguyen for 340 hours in manicuring. Records from the school state only 158 hours between that period of October through February 2015. Most of the requests from this school matched what the student had versus the school's records. So we at no time with Lyle School, where the student went, changed or altered the hours. So the hours matched as far as the record keeping. So if the board decides to release these, and that's what we've done with all the students, I would be inclined to release only the 158 hours. Her affidavit has a question mark next to the 340 as well, so it's kind of a guess anyway. So I'm,
Sounds like a good number to me.
Make a motion, we go with the recommendation.
That was the time on the clock.
Yeah, make a motion that we go with the recommendation.
There you go. I'll second.
All those in favor say aye.
Aye.
Motion carries.
so next we're gonna go ahead and review the reciprocity committee, and I'll let Ms. Coppinger take over and cover
Okay.
anything else.
We had 14 cases of reciprocity. 8, we granted reciprocity. 3, we required them to take both exams, the written and the practical. 2, we required just we voted to require just the practical exam. And then one, there was a extra little thing on this one person where we will give 75 hours credit toward their esthetician. It was just kind of an unusual thing, but it was pretty cut and dry. And we're trying to be consistent. So, anybody want to approve it?
Make a motion to accept.
I second.
Okay. All in favor?
Aye.
Okay, motion carries. Thank you.
Thank you.
Sure.
Okay. The legal report, I will turn it over to Ms. Tifa Teller to go ahead and update the full board.
We had minor changes in the complaint committee this morning, and there wasn't anything to bring before the whole board, was there?
Most of the complaints were pretty standard fact patterns. We did go over the complaint. I had previously told the board there was an issue with an inspector being intimidated. And we did go through that complaint. The board assessed a $500 penalty fee.
We did bring up
talked a
one
little
for
bit-
revocation.
Hmm?
We did bring up one shop for revocation for the second offense of unlicensed folks hiding.
Under blankets.
They're hiding under blankets under a
In
waxing
cabinets.
table. There were 4 of them.
Yeah, we
And it was
revoked
the
that.
second time
Second time in
where there had been several unlicensed people, so the board, the committee assessed revocation.
For facials, aesthetics, and still get them.
We spoke at length about having a 3 strikes policy. We're going to adhere to that when there is multiple unlicensed activity and fines. When folks are hiding or running out of doors, I think our recommendation is we don't need to wait 3 times, that we'll move forward with that pretty quickly.
Go 3 days in a row and probably get it.
And the report was humorous in that apparently someone yelled, "The state, hide," when the inspector walked in.
So they went under tables and closets, under blankets, in cabinets.
There had been several anonymous complaints, so a team of, we had more than one inspector go out there. I think an investigator or 2 went with them. So somebody walked in who they probably didn't recognize as being part of their annual inspection, and he's the one that heard them yell. Hide. And then when the inspector went to open the door where they have probably waxing room set up, someone yelled that they were not dressed, not to come in. So they said, well, we'll wait, get dressed. And then when they opened up the door, there was multiple people hiding under tables covered in blankets. So, revocation.
They were cold.
They were cold.
And it's somewhere in that shop, there's a client waiting or in the middle of getting their
Watching
nails done or
this.
watching this, so it's.
Yeah, so that was our biggest one, you know. So,
Make a motion to accept.
Second?
all in
Oh.
favor?
We have a motion. I'm sorry, it's your turn. Let me scoot back.
All in favor?
Aye.
Motion carries.
Okay, on your iPads, our consent orders this month are back in our hands, and we are so glad. We almost have perfect reports for the enforcement side. They're getting better. So we need a motion to accept consent orders for December, since our meeting was on the 14th. It includes most of December and January for a total of $33,100.
Make a motion to approve the consent orders.
Second.
Motion properly seconded to accept the consent orders. All in favor, say aye.
Aye.
Motion carries.
Then we have a separate report for our agreed citations between December and January, a total of $12,750. We also need a motion to accept that.
Make a motion to accept.
Second.
Motion and a second to accept the agreed citations for, is that January you said? For January. All in favor, say aye.
Aye.
Opposed, say no. Motion carries.
And we've got a total of 6 letters of warning that are issued on those complaints that are before you on page 177. We need a motion to be able to close those cases as well.
So moved.
Second.
Have a motion properly seconded to approve. All in favor, say aye.
Aye.
Motion carries.
Okay, the last item for your review, and I can't thank you all enough, we've moved. On your iPads, you've got 2 applications. These applications for reciprocity have not been updated since 1996. With the upgrade in core and all of the changes, the cashier's office is handling things differently. So you're going to start seeing, if you have students that finish PSI and share their things, PSI has worked closely with us, the testing vendor, to add transaction codes next to the license type. Has done changed anything for anybody but the cashier's office applying cash. So that kind of sparked this application needing to change quickly. And if you all will recall, that one of the laws that changed allowed us to collect the money for the reciprocity upfront. So that has been huge. That means that when someone applies, we're not waiting at the end 9 months later to collect the fee, or if they're advised to test, we're kind of working it all in the forefront. So the first application before you is cosmetology, the second one's for barbering, and the last page on your iPads is what the form looks like right now. What we've done is the chunk at the top, if you look at the old form, has, for whatever reason they did it that way, it made the applicant leave the top alone 9 times out of 10, not mark what they were. So they wouldn't say if they were an esthetician versus a natural hairstylist, which meant when the money got here, the folks in the cashier's office had no idea what this application would be and really got stuck. It didn't matter because things flowed a little differently, but now it makes a huge difference. And then again, we've added the paying the money up front. So if you'll go back to the current ones, we have numbered them 1 through 4 so that the applicant hopefully will be able to understand that the first part is to check off the license type. They need to tell us what they are. The next part is to add the photo. Half of them would not remember to send the photo, so it needs to be attached. The third piece is the main chunk of the reciprocal applicant, social security number, all of the address and so forth. And then the very last part is, at least still now, currently we are asking them to notarize this form. When we can do this electronically, that'll probably be dropped off. But given that we had so many issues with reciprocity, the legal team was always said, if you can keep this on the reciprocal applicants, leave it alone. None of our others still include the affidavit. But so if the board is okay with these changes, I would need a motion. If you've got any questions, please.
Are we looking at the fee issues with 50 versus 150?
We haven't touched it. This round with the changes that's gone through, we left reciprocity alone because it had just gone through the law moving it. But I think we need to the next time and make it consistent, because every now and then we'll get them to fill out the wrong form and overpay, and we owe them a refund. So
Motion to
definitely.
accept this forms.
This is, the $50 fee for the cosmetology is, on the cosmetology side, that's new. There was no fee before, right?
No, there always was.
Oh.
So what happened is we collected at the end when we were ready to
Oh, that's right.
license them. So
That's
it was
right.
just like a licensing fee, but you came in through reciprocity. Now we're going to get it up front when we start the work, which means if you're denied for some reason or told to test and you choose to wait 3 years to test, we've already gotten that money.
Right.
And in essence, after 6 months, that application's null and void. We could ask them to apply again.
We'll put some skin in the game too for folks applying that.
Yeah.
Yeah.
That's our hope, really, more than
Yeah.
the money up front is now you're committed to it, you're going to get us what we need. Because so many times they'll start the paperwork, not respond to the email, not send the letter, not send the name change, and we get stuck.
Yeah.
And, now we've got good metrics to figure out how to better do things and move
Awesome.
forward.
I think the forms look great.
Thank you.
We got a motion. Do we have a
Second.
second to accept? All in favor, say aye.
Aye.
Motion carries.
Chairman, we are ready. I have nothing else if anybody has questions.
I did have one more thing that would probably be under miscellaneous, if you don't mind. It's not on the list. Normally, whenever a school wants to take a field trip, we send a form in to Ms. Roxanna and she will approve it. We've been asked by a local veterans group to come down on several occasions to do haircuts for their veterans. We got that approved a couple of times, but they like to set it up on something like once a month. I'm not comfortable in asking for, 6 months or a year, but I'd like to keep paperwork to a minimum. I'd like to ask for approval to take our students, and I normally only take about 3 out of my school at a time, to go down there and to do that. It's normally on the second Wednesday of the month, and I would to approve that. And there is an exhibit that is currently still showing in Atlanta called the Body Wonderful, Body Beautiful. I don't know if any of you have seen it. I've been through it before. It is a display of humans that have been dissected anatomically, and it's a very strong medical display. I took my kids when they were young. They loved it. It's in Atlanta, and because it would be out of state to take my kids down there during their anatomy sessions, I'd like to get permission from the board, if I could, to take them out of state.
And I've been approving the hair show that schools go to in Atlanta forever. So,
Okay.
yeah, the board was comfortable with, because it's so relevant to what they're learning that.
Okay.
And so, since I've been given permission to approve, if it's relevant to their field, I think being out of state hasn't held me back at least either. So if the board's okay.
I'll get you a date on those
Okay.
when we do those.
That sounds wonderful. And quick feedback, so I'm glad you brought this up. A couple of weeks ago, I was in Memphis for the Shelby County Public Schools. Wanted me to do a question and answer session, and had 30-something instructors that teach a curriculum in their different schools come by. It was wonderful, because we talked about the hours, we talked about changes in the rules and laws, and then they even talked about apprenticeship, how it would work. They would handle it in their schools just like running any other co-op program. So it was really phenomenal, and one of their main educators that coordinates these type of things through the Board of Education was there, and she was thrilled. So we talked for a long time, and it was probably a full afternoon, and that was great. And then while I was in Memphis, I decided to coordinate other things. So met with the TCAT, the Tennessee College of Applied Technology Schools. They have the cosmetology program, and Memphis has the barbering program as well. So it was really great to visit the school, again, talk to the instructors, answer questions. They have a 3-year waiting list. So they're impacted by, what do we do to get students here, and they accept the Promise Act money. So they were really interested in different aspects and are very interested in the apprenticeship. So we covered that in length. And then when we finished meeting with that, the barber students weren't there. And so Ms. Pete Ernestine, that's come to several of our meetings, yes, so she's in charge of that. She said, well, on Wednesdays, because this was Wednesday morning, our barbers do all of their floor time at the men's shelter that's just down the road. So I went with them, and it was fantastic. And when it is, so we followed up, and I have our media person that, always shows things, and not always is it good things about our industry. So I think he's going to be able to coordinate to get the media to do something and show, because that site has between 200 to 300 men, they told me, every Wednesday lined up to have their hair done and the shaving. And the barbers are just fantastic, because at first, as I talked to the instructors, they said at first the students aren't thrilled about this. You can kind of see, and then they get into it and love it and know that giving back is part of the industry. So it was fantastic.
Sounds quite a bit like Operation Stand Down. We'll have, with 3 students, we'll have 150 people come through in 6 hours.
And those are the kind of things we need to share. I mean, I love hearing about it, so that if we can get somebody that's writing an article, something to share, those are great things for schools to do. Thank you. Yes? That's it?
Do I have a motion to adjourn?
Yes.
Do I have a second?
Yes.
You don't want to stay? All in favor said yes.
Who motioned? I'm sorry, who motioned?
Motion to adjourn.
Who motioned? You, Patricia, and Ms. Brenda. Thank you. Thank you. Safe drive home to
Thank you,
everyone.
everybody.
Thank you very much.
Thank you.
Looks like a safe drive home.